Good evening, ladies and gentlemen. This is the continuation of the hearing before the Municipality of Anchorage Board of Adjustment. Pursuant to notice, we are meeting again today on April 27, 2017, and this is the continuation of Board of Adjustment Appeal number 2016.1. When we left off last night, we directed our esteemed counsel, Julia Tucker, to prepare a draft of the decision. And she has done that, and we have this in front of us, and I'm not sure if all of us have had an opportunity to review it, but I think we need to start talking about it, because this is what our decision will look like, subject to amendments and additions and deletions, but this is basically the framework for our decision that we are coming to on the basis of the motions and the discussions that we had and passed yesterday. So, how should we do this? There are generally two aspects to a decision by this board. There is what lawyers somewhat flippantly call the boilerplate stuff at the beginning of the end, at the end, and there is really the body of the decision. And I would like to focus initially on the body of the decision. The other stuff I think we can easily fill in as needed. So, with that in mind, let's turn to page 2. There is a section that is entitled Review of Superior Court Order Reversing Board of Adjustment Decision number 2014-4 and remanding to the Planning and Zoning Commission for proceedings consistent with Superior Court Order 3AN-15-06026 civil. That is a section that goes to page 4, and I would like us to focus on this section initially. So, the first thing, just by way of starting out, I like the way this has been worded. It helps introduce the matter. The only thing I would like to suggest is that in the heading, Review of Superior Court Order, etc., that should there be any mention made that we are remanding it also already, or should that strictly be left to the section that's entitled Findings of Fact and Conclusions? What's your thought? Mr. Adams.
It would seem to me at this point, we had not remanded it, and we're building the case for remand, and so as part of the title, it's not appropriate.
Okay. Mr. Stewart.
I would agree that
Okay.
taking the remanding out, because we're concentrating on the Superior Court order and it hasn't been remanded yet.
By us. Okay.
Right.
Yes. Good point. Any problem with the first paragraph?
Oh, wait a minute. Rehearsing. No. I think that's okay the way it is, because it's referring to the judge's remand to the P&Z.
Right, to the remand order of the court, strictly. Yes, Ms. Tucker.
I guess that's where I got lost there. The title is not the title of this section is directly from the order. So it wasn't
It's
about.
called, why don't we simply calling it what the court ordered it, which is order reversing the decision of the Board of Adjustment. Order reversing.
Yeah, so what I did was I scratched out the other two lines after and.
I'm not sure I understand.
So this, what you are doing, Julia, is the title that the Superior Court remanded the decision to plaintiffs, not our remand.
Right, so why don't we?
Okay, I missed that.
Why don't we simply leave out those two lines? Review of Superior Court order reversing Board of Adjustment decision.
And I'm gonna leave in, if you don't mind, sir, number 2014-4, because that was
Yes,
the one that was, and so I'm,
right. So I think that way it makes it slightly clearer. Agreed? Mr. Stewart? Okay, all right. So, Ms. Tucker, we are eliminating everything following the number in parentheses there, 2014-4, from the caption, okay? Enters review of the current review. Public hearing. Should be a codon after hearing. Any problem with that first full paragraph?
I would suggest, that, well, just back up, as Dean may have explained, this was, printed off immediately, before we came down. And so, it is a rough draft. It might be simpler just, to substitute the word begins or enters, in the middle of that paragraph, so. The Board of Adjustment begins review.
Begins review.
Yeah, does that make more sense?
Yes.
Sir?
Begins
I like
its
that.
review.
And then a colon, you said, sir? after-
Yes, after hearing. And the rest is a quote that hopefully is correct. Any problem with that paragraph? Nope.
Okay, just before we leave, you're keeping the number of that Superior Court order in that caption, right? Okay.
Yes, sir.
Oh, I see what you're doing is, you mean the court case caption? Court case
No.
number? No.
I just
You struck
wanted-
that.
We struck the remanding.
Yes, everything relating to remand.
Mr. Stewart,
But-
you're just catching up a bit.
Are you a little,
No, but I thought that it would be, did you already say that you were going to keep that 3
no,
and put it right
Struck.
behind the court order on top?
no.
Oh, that's a good idea, though.
Because otherwise, we don't know what the court order
Right,
number
that's
is.
good.
Well,
So I think what
your
Mr. Stewart-
Superior Court order in case number. How's
Right,
that?
yeah.
Juliet, do you understand?
Yes, sir.
Okay. 3 etc. Okay,
Yep.
good point. Thank you. Anything else related to the first paragraph, including the quote? No? All right, then we come to the next paragraph on page 3.
One thing I'm curious about, more than anything else, is it's all in present tense.
Well, I changed that. We were recording.
Okay.
going to get to that.
Okay. I just wondering
In
if
other
that was
words,
a
yes.
released issue or something.
The Board of Adjustment notes that at the close of the public hearing on June 13, the Planning and Zoning Commission found itself facing two alternative routes.
And later on, when it reconvened, they were directed, or
Correct.
the commission was.
Was directed.
I have a couple of suggested changes.
Oh,
for the
two,
last
just one
sentence.
second. I think we need to reverse the order here of 2 and 1. Because initially, remember, they were not going to do anything other than hold this hearing, this what they viewed as a perfunctory hearing. So, I think,
I would tell you, sir, that I took this directly out of the pages of the record.
Oh, you did?
I'm giving you the transcript numbers on them.
Oh, no, that's fine.
So I'm happy to have you check that.
okay, no, that's
But I
good.
did the
That's
work
good.
to
Okay.
go ahead and do that.
All
So-
right, well, thank you. I stand corrected. All right, we are only talking about the first full paragraph on page 3. Mr. Adams,
Other than the,
we are only talking about 7 lines here.
other than the tense I had.
Yes, okay. Mr. Stewart?
Nothing other
Okay.
than what you've already caught.
All right, then let's go to the next paragraph. Okay. Anything regarding the next paragraph? Mr. Stewart?
In my research, I noted that AMC 3.60.055 decisions has wording that very similar to what's in the regulation.
Okay.
And the gist of that is the board or
We
commission.
are not at that paragraph.
Oh, I'm sorry.
You're jumping ahead. Previous paragraph.
Oh, no,
Paragraph that starts, the Board of Adjustment has compared, et cetera, et
no
cetera.
problem.
Okay? Mr. Adams?
Can I have just a
Of course.
second?
Well, Mr. Adams is checking that out. May I tell you the changes that I suggest for the last sentence of the paragraph that you talked about?
Okay, all right.
I believe that what I missed there was to read, as I'm going to say, this is the last sentence, the first finding in P&Z Resolution 2016-029 remains, and then add unchanged, and states, and then picking up with that the site plan complies. So,
Okay. The first finding in P&Z Resolution
2016-029.
2016-029, right?
Yes.
Okay.
029.
Remains,
Yes, and then add unchanged.
remained unchanged, not remains, remained unchanged.
And so this kind of gives, we say the first finding remains that it complies with the standards. One finding and two conditions are added, but the whole thing is identical. It's not just the first finding. All the findings are the same. And doesn't that merit some mention?
I think we should.
That, and I think you could phrase it, despite lengthy public testimony, the findings of fact remain virtually the same.
I think that makes it stronger.
Okay, despite lengthy testimony,
Public testimony.
public testimony,
The findings remain virtually the same. All findings remain virtually the same, with the exception of two conditions that are added, which are not findings.
and one new finding.
There was
Yes.
one new finding, I think, wasn't there?
One finding, because there was the sidewalk added, but the four remain virtually
So I have
identical.
despite lengthy public testimony, all findings remained, is that what you want to say?
Yes.
Yes,
Remained virtually
the same.
the same.
With the exception of one addition.
One addition. Okay, so that the last two sentences then read, despite lengthy public testimony, all findings remained virtually the same with the exception of one addition.
Yes.
Okay, and just leave it at that, and then refer to the addition in some fashion. We need to, two conditions, period. Two conditions relating to sidewalk and signage were added. How's that?
Sounds good.
And then,
Does that satisfy you a little better?
yes, and are we leaving in the first finding? In P&Z Resolution 2016?
No.
Okay, so the reason why the board talked about that finding last time, and the reason why I left that one in, is that is the finding that says that it complies with all the standards.
Yeah,
And so the discussion that you had was that there was kind of a gap. They made that finding, but that there weren't, that that's the part of the main crux. So 2 points being that, one, it looked virtually the same, and two is that when they did make a conclusion, the nexus between that conclusion and the evidence in the case and the reason for that
Are
conclusion
not
was
there.
missing. So I think that if you take that out, you're going to be taking out a big piece of the conversation that you had.
so
last
maybe
night.
we need to add that conversation in some language here.
I think you could just simply key that sentence in that you're concerned about.
Right, I just think you just keep it in. I don't think you have to go into the discussion
No,
here.
just add in
It-
what I'm suggesting.
Yes, that's what I think, because.
So you would like it to read what now?
Well, exactly what, the addition to the preceding sentence that Commissioner
Wait.
Adams, the board member
Wait.
Adams said, which is that after footnote number
One.
1, in the text, it would say, despite lengthy public testimony, all findings remain virtually the same, comma, with the exception of one addition.
Yes,
And then it still says, the first finding in P&Z Resolution 2016-29 remained that the site plan complies with the standards found
Yes.
in
okay,
that. And then omit one finding and the words and go with two conditions relating to sidewalk and signage.
yeah.
You want to say were added? I think it's a little odd to say that all these things are in the past, but it's the board's decision.
Yeah, I think we want to do that. We have done that in the past. So I would like to remain consistent.
Okay, so with that consistency, I'm going to go ahead and change that to
Yes,
were. That's why
yes.
I mentioned it.
Now, there was also, and we discussed the fact that there were problems with the adoption of the of the resolution. Should we mention that, or is that not worth mentioning here at all? Remember what the resolution was. There was a motion made, the motion was passed,
I understand.
and the resolution doesn't seem to bear any relationship to the motion that was passed.
And there was no evidence that there was ever a meeting addressing it in the future.
I'm not sure. I think
You think there may have been?
Wayne and I agree on this, that there's probably an oversight in the record, that they probably had it on the consent agenda at the next meeting.
Yes.
And just summarily approved it.
It's a standard
That's a
procedure.
standard procedure for boards. I mean, you know, I'm familiar with that from the zoning board. So I think that's the way it works. So I'm not sure that's worth talking about, but what was so striking was that they passed a resolution that really, or a resolution was signed that seemed to have very little relationship to the motion that was passed, number one. And number two, it was not based on findings. Findings were added after the fact. Is that worth mentioning?
I think it is worth mentioning. I think also that, I don't know that you need to mention it here in the preface, but I had a note down in following what I realized as I brought this down here was that even if it's just a procedural deficiency on a process about what you were just talking about, that it would be helpful to have a note that the record is incomplete.
Well, the appellant's argument on that is that it was, in essence, staff manufactured something, and then it showed up. Now, I don't know that that's accurate or not, but the fact that it's raised as an issue begs
Right, I think we should.
question. But it raised the issue of whether that stream, whether those connections, as we pointed out, were made.
I think we need to talk about the procedural irregularity of passing a motion
Yeah, I mean,
and
well-crafted
supplying
motion.
findings afterwards.
Yeah, well-crafted motion.
We need to
Right
craft
here.
a short paragraph relating to
Okay,
that.
let's put it in the parking lot, in the sense that you understand what a parking
Yeah.
lot is. And so I'm gonna take a note about that, so instead of getting bogged down on
Right.
four of us wordsmithing what that paragraph is gonna be about,
Yeah,
then, let's put it in a gap list and
Yeah.
come back to it.
okay. Next. As Mr. Stewart pointed out, the reference to 2110-304, that's a regulation, follows the code provision. And give us the code provision once more, please.
It's AMC 3.60.055, and it's labeled decisions. 60.055.
Okay. So Julian, would you add that, please? Board of Adjustment is guided by AMC 360-055 and by AMCR 2110-304, comma, AMCR 2110-304, and Alaska case law. So that we make a code reference there. Does that make sense? Okay. Let's go to page 4, the first full paragraph, following the citation of the case. It's a short paragraph, and there are just a couple items that I have. In the context of the record now on appeal. Would you add the word
In context.
in the context of the record
In
now?
the,
Yes.
got it, thank you.
Same paragraph, minor point, but I would put an and in front of 3.
Exactly. I was going to get to that. Before number 3,
Got it.
put an and. Anything else regarding that short paragraph, Mr. Stewart?
No, I don't see anything.
Mr. Adams? All right. Let's go to the next paragraph. I had some additions here.
One thing I'd suggest is prior to the start that it says, that it might say, of further concern, comma, the planning department memorandum should not provide guidance.
A further concern to the Board of Adjustment
To the Board of
is?
Adjustment. Just basically building
Yeah.
the case.
Is that the planning department memorandum dated, et cetera, and there I would like to add the following. Is the, was treated by the department and P&Z as a rule applicable to the case.
Okay, so this is.
Just following R 41-42,
So we have,
was treated
was treated.
by the department and P&Z as a rule applicable to the case.
Okay, period.
Period.
Okay.
It should not have provided guidance. Should not have, strike in this case, it should not have provided guidance because it was not adopted in regulation by either the planning department or the planning and zoning commission as required by AMC 3.40.
AMC 3.40.
Yes.
It was not adopted by regulation as required by AMC 3.40.
That's the chapter apparently
Right,
that
right,
talks
right.
about.
AMC chapter
Okay,
3.40.
okay,
Got it.
okay. And in any event, misinterpreted and misapplied the requirements.
And And what was that in any
And
event?
in any event, misinterpreted and misapplied the requirements of AMC 2155-130. Period. And the reason I'm striking the last words is it simply misinterpreted the provisions of that section, and that has nothing to do with the review of planning and zoning of the planning and zoning commission. So, let's see if we can make some sense out of this little paragraph.
Well, just to,
Yeah.
I think someplace, I mean, my understanding from your discussion and from the record is that that planning department memo may have misinterpreted and misapplied the requirements, but what is material to this case is the planning and zoning used that, and staff used that to instruct planning and zoning, and it's planning and zoning that considered it on issues material to the case. And so I may not have stated it quite right, but I think that just having a piece of paper out there really doesn't matter what it did if it's not tied into what planning and zoning.
But we already said that.
Okay.
But we already said that, because the paragraph now, as I'm suggesting, maybe incorrectly, should read, a further concern to the Board of Adjustment is that the planning department memorandum dated...
Okay, I got it. I got what
Okay.
Okay, yep. Got it.
Okay. Make sense?
Yep.
Okay.
Yeah, I think as a rule applied to the cases.
Right, yeah. Mr. Stewart?
I think it's okay. I see what she's talking about, though. She's talking about, they use this as a working document and a working rule, and I think
Right.
that was what they were trying.
Well, he already put that in there.
Right,
so
I put
just
it in there
wanted to-
already.
I was worried about that, but
Yeah.
I withdraw my concern.
Oh, let's not worry.
Okay.
Anything else? Okay.
No.
Then we come to number 2, findings of fact. First little 3 lines on the bottom of page 4. To reviewing the record. Board finds by unanimous vote. Number 1. The Planning and Zoning Commission conducted a public hearing on June 13 and July 11. 2. Planning and Zoning Commission provided the aggrieved parties with an opportunity to articulate their objections and to build a record for appeal through the public hearing. 3. At the conclusion of the public hearing and after deliberation, the Planning and Zoning Commission did not provide findings of fact and conclusions sufficient to document the proposed project's compliance. I don't like the word project in there. Compliance with AMC 2155-130A and AMC 2153-20. I don't like the word project.
Would you like to substitute the,
Because what this was a limited site plan review.
right, so would you like to substitute the proposed site plan amendments?
Yes. Site, that's exactly right. How the word document, to document the proposed. Anybody bothered by that word in there? demonstrate?
Or to address.
Or to address? Did not provide findings and conclusions.
Well, I took this one verbatim from what you said, and I, for me, the standard format for any compliance
Yeah,
thing is, what is the rule? What did you do? Where is it documented? So I
Okay.
appreciate the word document, but,
Okay.
but I understand that.
no, that's fine. If you feel good with that, who am I to say? Just first generation immigrant. Okay.
You could put to demonstrate if you wanted to.
No, no,
It's
no.
another good thing.
Anything else, Mr. Stewart?
No.
I guess
Yeah.
the only thing I wonder is we say to document the project. Well, the project changed from what was brought on and set on the table for consideration. So it didn't necessarily document. They did make some changes, what the petitioner brought in. They did accept that. And so it did change slightly. So the project did change. So when we say the project, it's what they did was that's my only question is.
Well, we already
when we
struck
say-
the word project.
Oh, did we get rid of the project?
Yeah, site
Yeah,
plan
so
amendment.
site plan amendment.
Yeah,
Site plan amendment.
never mind.
And it was amended. The
Yeah.
amendment was
Yes.
amended.
Yes, yes.
Never mind, I wrote it.
Okay.
I wrote it very nicely, as a matter of fact. Quite legible.
Are these the only findings we made?
No, you keep going down. I mean, I think that
There's
there
a lot
are
of
many
conclusions.
things, there's 21 of them. I mean, I put conclusions of law, but you started out with those findings, and then you switched to that, but I think that then
Okay.
So-
Then one.
the things that
Let me just finish my thoughts here. Did not provide findings of fact and conclusions not sufficient to document, but to document its approval. To document its approval of the proposed site plan amendments.
I don't think that that's what
No?
you were talking about last night. You made me worry about that today, but again, what's the rule?
Yeah.
How did you comply? And so it's not about the planning and zoning
Yes, yes,
approval yet, it's about the thing that you
Yeah.
talked about.
Okay. And you're right, we didn't make any other motions regarding that, so that's fine. Okay. Anything further that we should add? Mr. Stewart? No?
No,
You look puzzled.
yeah, I got a feeling there's a gap here somewhere, but I can't identify it. Maybe it's not.
Well,
There were two, and I'm not quite sure where to put them in, but there were two things that Mr. Adams talked about that I think should be worked in here, and I'm not quite sure if it will be up here or later on after after this. But the two things that were talked about last night that I had on my notes and incorporated, so that the decision reflects the dialogue, was that and maybe one of these is later on about the 10%, was that the applicant offered that sidewalk and didn't say, oh, I'm not going to do the sidewalk because of the 10% restriction, but that could happen under that. And so that's one kind of loose end out there. And the other one was that that, that the interpretation given by planning staff, the restricted interpretation of that code by planning staff, operated basically to discourage dialogue between the applicant and any affected parties. And so, I don't know if that goes in here, but I'm just saying that there are going to be some gaps here.
Well, I think it could be added.
And it can be added today, that's why we're having
I think that would help explain what part of why we got where we're at.
And I think that would be good as a finding, quite frankly.
Well, I think
The planning department's interpretation of code discouraged
any meaningful dialogue
any meaningful dialogue.
to resolve
Yeah,
potential concerns.
how's that?
Okay, the planning department's interpretation
Limited any meaningful dialogue.
limited or even limited?
Well, they
I'm
did
not
talk.
hearing
I mean,
you.
they
Yeah,
talked. So I would say it limited.
Yeah, my thing was I wasn't hearing, not.
The planning department's interpretation of applicable code sections. Erroneous interpretation. Because that's really what it was.
Yes.
Limited dialogue,
I would use meaningful dialogue.
meaningful,
Or productive dialogue might be better because that's where fundamentally we're trying to get some resolution prior. So
productive dialogue.
Between the petitioner and concerned parties.
Among petitioner and
Is it called petitioner or applicant? What are they called here?
is an applicant.
It's an applicant.
Well, isn't it all parties to the hearing?
That's better.
Yes.
Among all concerned.
Yeah.
The planning department's erroneous interpretation of applicable code sections limited productive dialogue among all concerned.
Yep. That's
Okay,
good.
is that, I got a question. Is that tantamount to a chilling effect on the due process hearing?
Not in the hearing because it doesn't limit the petitioner from, a petitioner can walk up and talk about virtually anything, so it doesn't limit their ability to voice their approval, and I think if you look at the record, they did voice their approval. They brought a lot of stuff that wasn't even germane, but the commissioner's job was to parse that out. So it didn't limit that, but what it did is stymied discussion
Yes.
beforehand.
Okay.
And again,
Okay.
Yeah, I would not wade into the
All right.
due process argument, quite frankly. Simply leave it as a finding. So that's an additional finding, number 4. Any other finding that we should add? Anything else? Okay. Hearing none, let's proceed to the next section. Conclusion, strike of law. remember we've had that discussion.
Well, there's a difference. I actually looked this up. So when we were talking last night, I was talking about planning and zoning, and we were attributing something to planning and zoning, and we were saying that their findings of fact and we put in conclusions of law. When I looked up their code,
We have always simply called it conclusions.
okay,
And simply call it conclusions.
and I don't have to say by the board?
No.
Okay,
Conclusions. And the consecutive numbering, we need to change the first one to 5 and then go through. So what is written here is number 4 becomes paragraph number 5. Any issues regarding that, other than there are a couple Ds that need to be eliminated? On the third line, between the relationship between evidence and findings, and between findings and the ultimate action.
okay, so I have one D eliminated. What was the other D that I need to eliminate?
Same line. The evidence, strike the findings, strike the, and the ultimate action, strike the. So that says
3.
the relationship between evidence and findings and between findings and ultimate action as required by code and Alaska case law.
I'd love to strike these and that. I'd love
These and those. Anything else regarding that paragraph?
No, not for me.
Yeah. Let's go to what is labeled number 5, but should be number 6.
Should members be a small letter instead of large?
I'm sorry?
Should members be capitalized or?
Small.
Small members. We're just, oh, it's planning and zoning committee. Yeah, they're also small members. Deficiency. Next paragraph concludes that the deficiency in the record regarding the relationship, not on the relationship, regarding the relationship between, and then we need to repeat that, between evidence and findings, and between findings and ultimate action pertains to issues material.
And the Board of Adjustment is not in a position.
In a position. We are not in a position to remedy the deficiency without remanding it back. I look at this differently. We are not in a position to remedy the deficiency of our own, and therefore we remand it back.
I guess simple syntax, remand back, is back to remand to the planning.
And therefore
Oh, it is.
remand.
Okay, so I'm lost. You'll have to
Okay.
repeat for me. I'm not in disagreement. I'm just
It
lost.
is not in a position to remedy the deficiency, and therefore remands the case back.
Remands the case. Remands the case. Back to the planning zone.
No, just to,
remands-
remands the case.
Remands the
Yeah, strike back.
case, period. Do I need planning and zoning in there, or am I taking that out?
Planning and zoning still.
That's fine.
Remands the case to planning and zoning. And therefore remands the case to planning and zoning.
Goes to the planning and zoning commission. I think that's the, sorry about that.
Okay. Next one.
Yeah,
Any further changes to what is now number 7?
No.
Okay, then let's go to the next one. Trust the board has concluded there's insufficient evidence. Do we need that?
Yeah, this is the one that I think that ties to your jurisdiction to remand. So what you may not need is anything. That's why I put the other one, the one above, I tried to make that you're not in a position to decide I mean, you're deciding
Well, then why
to
don't-
remand. So I can sort of,
Well, okay, well, if we want to bifurcate that, that's fine, then let's go to the previous paragraph and change the sentence to read, the Board of Adjustment is not in a position to remedy the deficiency,
right,
period.
right.
And then the next paragraph talks about, there's insufficient evidence in the record.
That's your threshold. So this was my rationale about this. In the same way that the court in the remand order talked about how important it was to have that sufficient record. For the Board of Adjustment, you need to have the record that the appellant is talking about. That the appellant needs the same record for the Board of Adjustment to decide if the planning and zoning, if there was sufficient evidence to support the findings. You need to have a decision that actually establishes that nexus. So,
But I must tell you, if I were to be on P&Z and I'm handed this suddenly and I'm looking at the sentence, I would say, what in the world does that mean? Do we have to reopen this entire thing? Or do we simply go back and come up with better findings and conclusions?
that's a good point.
okay.
So what I find misleading in that paragraph is the words, there's insufficient evidence in the record. Because the record is there. What isn't there is a proper decision.
So wouldn't it be a substantial procedural error then?
Yes.
We have,
But if you look at your code, that's what I try to get around that one, the substantial procedural error requiring public testimony. Those are your, look at your ground.
which requires further public hearing.
Yeah, which requires further public hearing. So are you thinking further public hearing is small p, small h? Or do you think it's testimony?
No, not testimony.
I'm asking him what he thinks that code means.
That. We're
I think-
trying to get away from that.
I think they have to have a public hearing in order to correct.
Yes, that much is clear.
Public meeting or public hearing?
Public meeting.
Well, public meeting.
This is a
Public.
meeting.
Yeah.
Let me see what this 2139.
What's the,
Well, how about if we just, I had trouble with
so you're throwing it to us.
no, I'm not trying to do that.
What is,
Now that I'm hearing what you're saying, because I didn't hear before. Because the Board of Adjustment has completed
Well,
the record is deficient, so Let's conclude the record is deficient.
Is the record deficient though?
It's not the record. It's the decision that's deficient.
And we could just say the findings and conclusions are,
Well, you said before in the new number 7, the Board of Adjustment concludes that the deficiency in the record regarding the relationship
Evidence
between the
findings.
evidence.
Yeah.
So that's how you
And action.
defined the deficiency. So
Yes.
I think that that's a good definition of the
Good.
deficiency. And so then just scratch the first part and just pick up with the Board of Adjustment remands the case to planning and zoning.
Yes, and just leave it at that.
For decision in compliance with code, because that was
Yeah.
the little part, we were getting all wrapped around the.
And that would include 1 and 2.
Yeah.
Yes, exactly.
There we go.
Yep.
it's funny how simple sometimes works.
So we strike the entire first portion of that sentence and simply start out, the Board of Adjustment remands the case to the Planning and Zoning Commission for a decision in compliance with code.
Correct.
Does that make sense?
Right, yes, it does, absolutely.
okay.
So like you said, there was a lot of repetition in there, and I kept going and,
Yeah, okay. Decision-
do if they copied it all down, that's right.
What's your intention with what's numbered here, number 8, and that should be number 9? What are you trying to say?
Well, that's what you do, you substitute your independent judgment on legal issues relevant to the case, and so as you look at the next suite. of
So that's
things,
really
those
what
are
you're,
all-
so it is to be an introduction, really,
Right.
of the next one.
Yes, so take
So-
out the number.
I would,
Yep. And then we're gonna be back with good numbers again. I like it.
and offers, and because it also says here that we can offer, so wait a minute, there's something here that I like in the language. That we give direction, by way of giving direction. See, I want this to be, that paragraph to be an introduction to the next couple of pages,
Right.
okay?
Okay, so what
And,
code are you
and so
looking at?
when you look at, because what we're really doing is,
Wait, 21, what do you got?
this is 213100.
So can we
The
say,
decision remanding the case shall describe an issue upon which further evidence should be taken and shall set forth any further directions the board deems appropriate.
so can we say at the end of that sentence, and provides direction as follows?
Yes, I think that's good. I like it.
Colon.
Colon. Look at number 9. I think we should combine 9 and 10 in some fashion because it pertains to the same subject matter.
We could scratch the number 10. We could, and just say it is in conflict. That's what you've done, that would be
Yes.
consistent with other changes that you've made.
Furthermore, it is in conflict. Oh, have we described the interpretation? Our own interpretation? Have we talked?
Not yet, you've gone.
Not
through
yet.
it. This is where you
Okay,
go and
that's
do
the,
it.
yes, okay. Period. So we say it is. So we strike the number 10 and simply say, following number 9, it is in conflict with Board of Adjustment's interpretation of AMC 21-55-130.
And maybe this last clause, you need to move up to start it. So you really have kind of three things all in the same
Yeah.
paragraph, but start out with in reliance on planning department memorandum dated September 2nd, the planning department has misapplied material provisions.
Of code. So we start out with that.
Well, that would be one option. We start out with, I guess I would scratch the furthermore and just, the planning department memorandum stated was not adopted.
Yeah.
Then go to number 2, then go to in reliance, and then 3 is that it's in conflict.
I think that makes some sense to do it that way.
It is in conflict. Well, maybe the in reliance one is like what you had, what you told me before, that was kind of an introduction. So you have.
I'm amazed that there are people in the audience who are looking at us and they have actually very little idea of what we are doing here.
Movie theaters are open.
I'm sorry. Get back to this. I would like to wrap these two paragraphs, 9 and 10, into one, first of all. And maybe the way we start out is conflict, the portion that talks about the conflict with our interpretation should be the last portion, because then there should be a colon, and then there are the following 4 paragraphs of whatever we make. Okay? So we should start out by saying the planning and I'm just conceptually verbalizing
Are any
this.
of
Planning
these
department.
Excuse me, sir.
Yeah.
Sir, you before mentioned that we had some gaps in the findings.
No,
Are any of these findings that should be moved up?
no, I don't think we do. I think we are okay.
You don't think that the planning department memorandum dated that was not adopted by those regulations doesn't have corresponding with the findings?
That would be that procedural error.
Didn't we talk about a procedural error somewhere? We did. We made a finding The last finding, the planning department's erroneous interpretation of applicable code, and that's what the memorandum is, limited productive dialogue between or among all concerned. So we are talking about that already.
Right, so maybe these are findings that go in front of that. Because that's sort of the I mean, that's what made me think about that. The third finding, I mean, it's part of what, I mean,
So,
we got late last night and so.
well, we have number 4. We have 4 findings.
Right, but I would suggest that, that in, finding number 3 is at the conclusion of the
Yeah.
public hearing.
Right,
Site
right.
plan amendments. And then a new number, 4 would be the, planning department memorandum, was not adopted, or, you know, any one of these 3 things that you want to pick here. And then what you number tonight is number 4 would then be, a different number.
So do we need to refer to that?
Well, I just think you
As
just
a-
move that up. You just, I mean, if you decide to do, because otherwise, see, you started in the paragraph before, immediately before, if you look on page 5 of 8, you already have a colon, provides direction as follows.
Yes,
Okay, well, you're not gonna have something else that
That's
provides
true.
another colon. And so it seemed to me that,
Yes.
as I was listening to you, that what.
you are right. Right,
what
those
we're doing-
things should go further up because it is not a recommendation.
Right.
Okay, so we
Or a
need to put
direction.
that.
It's
or
not a direction.
It's not a direction. So we should put that elsewhere. And,
And since you've already, as you just pointed out, added one that had to do with this, the one that you added said the planning department's erroneous interpretation. So that
Yes.
falls
okay,
right
so we,
after the.
yeah, so we should, number 9 and 10, we combine and make it a finding.
Or you leave it as 2 findings and you move them up.
No, let's turn it into one. So how do we turn that into a finding? Isn't,
Well, I think that the business about it not being adopted by regulation doesn't have the force of law as a standalone finding. And so you may want to reorder the order of number 10, of what on here is number 10, so that it goes in. But it seems to me that in the context of what you've done so far, that when you look at number 3, you have at the conclusion of the hearing, they did this and this.
Yeah.
Then you could start out with the planning department memorandum, the planning department memorandum dated
yeah,
September of 2009 is in conflict with the board's interpretation of 2155-130, period.
is that a finding or conclusion?
Okay, that's a good point. Okay,
That's a conclusion.
so you leave that one here as conclusion number 9, and you move what was 9 and and combine it with the second sentence of 10, and you move those up as findings. So yes, you would combine them, but you would leave the conclusion under conclusion, which would be the first clause. And so,
Okay, all right, so number 9 becomes a conclusion that should be put ahead of our direction paragraph. So it remains number 9, but gets moved up 1. How is that?
So if I understand this part right, under conclusions, before we get to the paragraph about directions,
Yeah,
there would be number 9, and number 9 would say the planning department memorandum dated September 9, 2000, September 2nd,
yeah, it was not
2009.
adopted and it does not have the force of law. Yes.
Okay. All right, and then are you going to, on what was number 10, do you move those two sections,
To
or
find
at
it.
least one of them, the second part?
I
in
think-
which the finding part of that seems to be in reliance on planning department's memorandum dated 2009.
Yeah.
The planning and zoning has misapplied the material provisions.
Yes.
I agree, that's a finding.
That's
That
a finding.
clause,
That's a
that goes
finding.
in the finding above the one that Mr. Adams suggested earlier.
Yes, correct.
Okay, so now.
So this becomes finding number 4, and Dwayne's suggestion becomes finding number 5.
Right.
Okay, I
Now-
think we're getting there.
Now I have the first paragraph, which is, the first sentence, which is the planning department memorandum dated that is in conflict with the board's interpretation. Now, do I keep that in place?
Why don't we add that to number 9? The planning department memorandum, etc., etc., was not adopted in regulation, comma, does not have the force of law, and is in conflict with the Board of Adjustment's interpretation.
I get it. Okay.
Okay, and then,
Then we've dealt with everything that was in
Yeah.
9 and 10, we have a place for that. It
Right,
just
right.
doesn't happen to be under the direction to the, it was.
yes,
Okay?
okay, good. So then we come to what's currently labeled number 11, and I must tell you, we've got to do something here, because 11, 12, 13, 14, and 15, and 16 all talk about the 10%. No, 11 doesn't, but 12 and all of those. So let's first look at number 11, I'm sorry. The exemption for interior work does not apply. The exemption
In 21, in AMC 21,
in
55,
AMC 21, 55, 130A. The exemption from what?
the exemption in that for interior work.
No, the exemption from site plan review. Isn't that what it is?
Yes.
The exemption
From
limited
limited
site
site plan,
review.
site plan review in AMC, et cetera, for interior work does not apply where an application for limited,
Well, we said the same thing twice.
the exemption from limited site plan review for,
See, I thought that the board's point was that when you look at that exemption in 2155-130A, the exemption for interior work that doesn't apply where an application for limited site review is under consideration. You guys looked at it quite a bit. Then I got
No.
lost where it says,
no, what we were saying is that the exemption really only applies when you're moving interior walls and things of that nature. It does not apply when a
When
limited
it's
site
built-
plan review is required.
Yeah, well, maybe that's when
I think
it
that's
does not
what,
apply if or when an application for limited site
Plan
plan
review
review
is required.
is required under,
no, is required.
okay.
It's pretty explicit.
Yeah,
Would that make more sense if we took that, the first part of that, or the first sentence, and put it behind the last sentence then?
the sentence in.
One is positive, and then one is negative. So we're addressing the positive that says it applies only to the interior projects, which are basically standalone projects. And we're saying then, however, the exemption does not apply when there's an application for limited site plan review.
I think that looks good, I just have to fill out.
So you want to turn it around?
Put the positive before the negative.
Yeah, put the positive before the negative. I think that's fine.
Because it really helps explain
Exactly.
the exemption.
And not the sentence addressing the exemption from limited site plan review applies to interior only projects if the effects are limited to the interior. If the effects. If, no, that doesn't. From limited site
Would it mean?
Okay, so that the paragraph would start out, the exemption from limited site plan review for applies only to interior projects
Well, that's not the only exemption, so that's what
Yeah,
I don't think that
I
that's.
think we need to, just stepping back, 12, 11, 12, and 18 are closely timed. And I think 18 probably needs to, 11, 12, and 18 need to be grouped together because they're talking about, and 18 is what finally
Right.
summarizes it. And that probably needs to move up, and they can be made 2, they can be 3, but I think there needs to be that train.
I would like to combine those in some fashion.
I would too.
Okay, so you want to start off with number 18?
Well, just combine them. I think.
We need to
It's a-
combine
it's a-
those in some fashion.
18 is kind of a summary
Julia,
statement that
that's-
I think is the nexus of the discussion.
Yeah.
I think swapping those, as Mr. Stewart suggested, makes sense on 11.
Yeah,
And then 12 can be added into that same sentence. And then 18 could even be wrapped in, or 18 could be a therefore.
So when you say about the swapping, would it be that so starting with the swapping, would it be that the sentence in AMC 2155-130A addressing interior remodel/renovation provides an exemption for for interior only projects if the effects are limited to the interior. Then say however, the exemption
Does not apply where an application for limited site plan review is required.
Is required, yes.
Okay,
okay, so have a however in there
yeah,
to do those two. Then we have required, and then the proposed, then pick up with 12. And then do you want these all in one paragraph? Is that what you're
I think 11 and
suggesting?
12 could be combined quite easily. I mean, it's a nice
What-
summary statement.
why do we need number 12? We are already saying the exemption doesn't apply where an application for limited site plan is required.
Yeah, I think they can make the leap that that's what they're.
I mean, do we even need 12? That's my point.
Or do you want to add it as one of your findings, even though you have it here?
This is almost in terms of a finding. Because.
Number 12,
Yeah,
the proposed site plan.
Maybe
Oh,
you stop
simply-
it at the
and simply
project and then s-
Yeah,
the
and
rest.
stop, and scratch the rest. The proposed. Is it proposed? No, we shouldn't say that anyway.
Why isn't it?
The limited site plan review.
But that's what the review is. It's for a proposed site plan amendment. That's how that works.
Okay, all right, yes. The proposed site plan amendment in this case is not an interior-only project. That's a finding.
mm-hmm.
Finding, okay. Number 5.
Well, now
That'd be
find
actually number 6.
No. You want to follow that, want that to follow Dwayne's magic paragraph
Yeah.
about the erroneous interpretation? Okay, that's fine. Doesn't trouble me. So we make this finding number 6. What is presently labeled as number 12 becomes finding number 6.
Abbreviated.
Yeah,
F and end
correct.
of project period.
yes. Good.
And then going back to.
And then go back to number 11. Swap the sentences. And number 11, remember? Come up with a proposal with a positive first and then the negative. The exemption from limited site plan review applies only
That's
to,
the second part. So we're starting that sentence with the sentence addressing interior remodel.
no, we were going to change that, remember? We were going to swap the sentences. The exemption from limited site plan review applies only to interior projects, period. The exemption for interior work does not apply where an application for limited site plan review is required.
Okay, so why don't you say that back to me again, because.
All right, so redo a new paragraph 11 and simply start it from scratch, because otherwise you can't read your own thing.
Right.
The exemption from limited site plan review applies only.
The exemption, and that's where I asked you, what exemption?
The exemption from limited site plan review applies only to interior projects. Period. The exemption for interior work does not apply where an application for limited site plan review is required. Does that make sense?
Yes.
I think so.
That's
The only thing you need to add, Julia, is the statutory reference.
Okay, so do we have, okay, so I have the exemption from limited site plan review in
Yes, in AMC 2155-130A
55-130A.
applies only.
Okay, so what I'm suggesting is that somehow when you're starting out with the exemption, and there could be all other kinds of exemptions in that very big long paragraph.
No, the
So-
exemption from limited site plan review.
But there are lots of exemptions from, potential exemptions from limited site plan review in that paragraph.
Okay, this is the one we're referring to, the
There's
fourth
There's
sentence.
only one,
To the fourth sentence, so that's why I'm saying, so.
contained in the fourth sentence.
Thank you. Applies only to interior projects, period. The exemption for interior work does not apply.
Where an application for limited site plan review is required.
Application.
I think that makes it pretty clear.
Limited site plan review is required.
Required.
Okay,
Doesn't, okay?
okay.
Good
Now,
deal.
what will that number really be?
That will be number 11.
Okay.
Nope, hang on. This becomes number 9, becomes number 10, I'm sorry. Becomes number 10.
Well, number 9, isn't 9 of this.
Well,
Number 9, you said goes
yeah,
up
yeah,
to
we-
the 9.
So we had
above.
6,
No, we
7.
already,
Yeah,
remember,
It
it goes 8, 9.
Or no, 12.
Yeah, no, we're fine. Oh, we are adding findings, okay, so we need to remember that. Okay,
So
Yeah.
I'm thinking
Right,
this is
right,
going to
right,
end
right.
up being
12 or
I
something.
think 10 becomes 12,
Yeah,
something like that, but anyway.
yeah, anyway,
and then
okay.
11 becomes 13.
So, now let's go to, we have already dealt with what's currently labeled paragraph 12, because that becomes finding number 6.
Right. So
Okay,
it's just
so now let's go to number 13. And when you
Okay.
look at
Well-
13,
Well, do you want to put 18 in there
I
now?
think 18 we need to look at first, because 13 through 17, or 13 through 16, all deal with 10%.
correct.
18 deals, again, it says exception, but it's exemption for interior work in the fourth sentence, which we just talked about.
So would you like to add that?
Well, I'd like to move it up, that's all.
Is it necessary?
I think so.
It's a
Absolutely.
Okay.
it's a definition. It allows more
So it
flexibility.
should become an additional sentence to what we just tinkered with.
Yes, we could just add it to that paragraph.
Yes.
As a final statement.
Exactly.
I-
Do you understand what we're saying? Okay. Okay, so we move that up. And Bob, you said what's currently labeled number 11 will become what now?
I think that becomes 13.
Okay, so that will be added to 13. Okay, good. Oh, we're making progress. I like it. Okay. we have 4 paragraphs that talk about the 10% cost limitation. What's presently labeled 13, 14, 15, and 16. And I think we need to somehow come up with a solution to combine those. 10% cost limitation.
Yeah, among other things, if we look at 17, we talk about compliance as of May 8, 2001. And in 13, we talk about the, for 14, at the time of the application. I think those need to be the same. So that's one issue. In that.
Oh, well, I think that.
No.
Yeah, I think that they went to 2 different things. So-
That's 2 different things.
Okay.
So maybe we need to amend 13 so that it's not ambiguous that way.
And it's not, the 10% limitation of cost of compliance.
Limitation, I think is what it is.
Yes, it is a limitation. The 10% limitation of cost of compliance contained in,
Or do you want number 13?
yeah,
In A and C?
yeah,
I think it's-
applies to the whole. And do we have to use the term grandfathered? Remember, it is not grandfathered.
Well, yes, it is grandfathered.
It is grandfather.
No.
Yes, it is.
Yeah, that's, there's 2 things we have is there, it is in conform, I mean, it's
Correct.
an approved.
Yes,
approved
that's the
site.
term. That's the term that's
and it was
used.
grandfathered, and it's used in code.
That's right. And so what isn't grandfathered is non-conforming.
Non-conforming.
Non-conforming aren't grandfathered
And that's,
because they are not considered to be approved as of the date. So grandfather
Right.
applies specifically to things like this.
yes.
Okay, you're right. Okay. And the reason we have paragraph 13 is because the department said you only need to spend 10% on the exterior. Remember, that was the whole point. And
Well,
so,
their point was that you get the 2 things about that. One was that the 10% is calculated based on the footprint. The cost of whatever the amendment was that changed the footprint. And if you're doing a site plan amendment, even if you have to do a site plan review, and it doesn't change the footprint of the building, then there's 0. That was one problem.
but they didn't, that's not what the department came up with. The department came up with saying they need to spend $30,000 because the whole thing costs 300-some thousand.
Because the only thing that they were looking at was the footprint, what the part of the project
Beyond
that
the
changed the
footprint.
footprint. So they used that memo and they said, okay, here's the great big site plan, it's gonna do this and this and this and this, but the only thing in the site plan that changes the footprint of the building is the loading dock.
Doors.
No, it's the
Not
loading
even-
dock.
It's the loading dock, yes, correct.
It's the loading dock, and therefore the cost of the loading dock is this amount, and therefore 10% is this, and so you're
Yes.
limited on everything that you do.
Correct.
10%. So that's why you came up with all of these different angles to it, because the 10%
Yes.
affected more than one aspect of the rest of the interpretation.
Okay, so how are we going to address that issue here?
Well, one thing that I thought of when I was typing these up from from last night is that you could pick one of these as your introduction about the 10%, and then say these other aspects apply, give a colon, and then do the other things as bullets.
Yeah.
Because otherwise, you're going to end up with the same thing that is the problem with, that I worry,
Yeah.
you end up with a risk that you're combining all these complex angles of something into one turgid paragraph in your decision, and that
Okay.
hasn't proved helpful to planning and zoning.
Correct.
when
So
the
really
code did it that way.
so the introductory sentence maybe should come from paragraph 15. Planning and Zoning Commission is not limited by the 10% cost limitation. And then make bullet points. Is that what you're suggesting?
Yes, I think any of those could. I was wondering if you wanted to we were starting with that number 10, the 13, but I think 15 is a good one, and then have 13, 14, and 16 be bullet points under 15.
Okay, so then let's look at 15 first. Planning, not limited by. So, how about using just the first sentence of 15? And make the second sentence the first bullet.
Right, and maybe in the first sentence in number 15, it's in its review of the renovation, remodel, / remodel application.
I think we should call
Or
it the
site
limited,
plan.
I think we should call it the limited site plan review, because that's what it is. In its review of the limited
Well, that doesn't,
No.
it's an application for site plan
Plan
amendment.
amendment.
That's what,
it is, you're right.
yeah. So the lead-in sentence of the Planning and Zoning Commission is not limited by the 10% cost limitation in its review of the renovation / remodel application for site plan amendment.
Yes. In its review of the renovation / remodel project of the,
I don't think you need project in there.
okay, remodel,
And
I think that makes sense.
of the limited site plan amendment.
well, what you're, so that the other way to do it is I could put all the many words that they repeat for expansion, reconstruction, renovation, or remodeling. And so instead of saying the expansion / reconstruction, renovation, or remodeling application, that's the type of application. It's an application for site plan review for this, remodel project.
Yeah,
So renovation / remodel that modifies application.
okay.
In sort of this kind of shortcut way. The question is, does that shortcut way? And I took out project because you guys
Okay.
talked about not using project earlier, but last night we kept using project.
So you want that sentence to read, Planning and Zoning Commission is not limited by the 10% cost limitation in its review of the renovation / remodel of the limited site plan amendment?
No, it's not so much what I want. I'm just suggesting that what you're what you're saying is that the Planning and Zoning Commission is not limited by the 10% cost limitation in its review of the renovation/remodel application for site
Application.
plan amendment. Period.
Application, yes, that's good.
So it's a limited site plan review.
That's what a limited site plan review is, but if you keep using the word review over and over again in a sentence, then it doesn't make any sense, it gets confusing.
Yeah.
The limited site plan review, what it does, and this is my understanding from everything that's gone on before, is that that if you want to make a site plan amendment in 2014 or whenever this started, if you want, you've got a great big site plan over, grandfathered LRE site plan over there at the mall at Sears, and now you want to make an amendment to it. It was grandfathered in, that whole
Okay.
large site plan, it was grandfathered in. I'm talking to Mr. Stewart, so whenever you want me to stop, I'll stop, but, so the whole great big amendment,
Yeah.
the whole site plan, that's called the big site plan, so it covers the whole situation over there. And if you want to, in 2014, make an amendment to that, you have to do it. You're gonna amend the
So-
site plan because you're gonna have an addition or something to it
So
that's gonna modify it.
they're reviewing the proposed amendment,
Yep, they're reviewing a proposed
Proposed
application.
amendment.
or proposed
For-
application.
A proposed,
Application for a proposed
Yes, sir.
plan amendment.
yep, site plan amendment, you got it, that's
Yep.
good, that's good.
Okay. So that's the introductory sentence. And then we make a bunch of bullets. That was your suggestion. And I think that makes sense.
And then the first one, did you want the first one to be that second sentence of 15? And then,
Yes.
and then project may make more sense there. The renovation remodel project is required to maintain conformity with code.
It's a good book.
Yep.
Okay, so that's a bullet.
Okay.
Um,
Then, what do we do with 13?
well, we're gonna make it a bullet. That's how we started here. If it's not
Mhm.
deleted, then it becomes a bullet. Then the 10% limitation of cost.
On 13, I guess one thing I'd suggest is we have, it's a conditional statement. 10% limitation applies to the whole grandfather. Once it is determined that limited site plan review approval is required, why don't we just say the 10% cost applies to the whole site, period?
Yes,
Okay.
applies to the whole grandfathered site,
Yes.
period. And leave out once it is determined, et cetera, et cetera.
That's cleaner.
You want
That is
that.
much cleaner, and that's a nice bullet. Okay. How about number 14? The way it is?
I like it.
I like it the way it is.
Okay.
I guess the only question is we say, well, I think it works fine. Wondering, but getting back to my earlier statement, from compliance as of May 8, 2001, we're going to deal with that, but I think it's fine, it works.
Yeah, I think it does.
They are non-compliant issues under the code here.
Right now or then.
Yeah.
but it doesn't matter,
Correct.
it's still fine.
So what do we do with number 16?
Well,
Haven't we said that already? No? The 10%?
The
No, that's
10%
the
cost of
the
compliance.
Cost of the entire, so what you've done is said, what,
No, that needs to be a bullet, most definitely. Because that addresses the calculation.
and maybe the sentence should say the calculation of the 10% limitation. Because that's what you're
Yes,
saying about,
correct.
to keep it in conformity. with-
Yes, Okay, so we have 1, 2, 3, 4 bullets.
Yes.
A, C, D. Yep.
Okay?
Yeah.
And you can make those either bullets or you can label it A, B, C, D item.
Oh, yeah, that's a good idea. I like ABC.
Okay. All right, and I think we need to take a break here. Or do we want to forge ahead? We have another,
Well, before we forge ahead, that 15 then becomes 14 with all these other bullets.
becomes 14, you're
Yeah.
right. Correct. Okay. Do we want to forge ahead and do the last 3 paragraphs before we take a break, or do we want to take a break now? What's the problem?
I could
We
use the
have been-
bathroom. I could use the
I
bathroom.
think,
break.
well, why don't we take a 10-minute break? Recess for 10 minutes. Getting a little
And as the
hungry.
clerk pointed out, you have sandwiches in there, or what are they?
Well, that's very
Pita.
good, because I haven't eaten since breakfast.
There's a
Pitas.
Pitas. Wraps.
So
Okay.
there's ham and turkey.
I don't know whether you noticed, but at yesterday's hearing, I started getting a cramp in my left leg,
Oh,
right,
no, I didn't notice, but I'm sorry
Right.
you did.
right in the back, and but that's because I stood all day. I mean, literally. I was standing, reading and going through all this, and I had a contractor on one hand and all my stuff lay down on a
Oh, dear.
place and on the other
Mhm.
hand. But that's why it cramped up, and I
Uh-oh.
just felt a little bit, a short one tonight, but
Mhm.
that's why I stretched it out.
You know what you, maybe I didn't see it. Didn't address the facts like.
I don't know, we do last night. So I wonder. Okay, so we got some gaps.
Yeah.
I
The
know
only
we
one I can
addressed
think
last
of.
night, and I found the question.
Mm-hmm.
And then the parking lot issue.
to forge ahead? Julia, are you okay? Tell me when you're ready. You're not?
No.
Okay. Take your time.
Got it. Okay.
What happened to my thing?
I took your plate up, I'm sorry.
Well, thank you.
I just thought.
I
all
meant
of our
to
papers
say-
here.
No, that's just fine.
I took
Yeah,
mine up
thank
as
you.
ready.
Well, thank you.
Okay, so. I think we're getting there. I'm very pleased. Tell me when you're ready. Okay.
All right. Barbara, are you ready?
You're on the record.
Okay. We are back on the record in appeal case 2016-1. We have concluded a substantial number of directions here, and we now need to turn our attention to number 17. There's what's currently labeled paragraph 17. I'm not sure what it should be. Probably 15, right?
Yep.
Okay. And enumerated considerations in the first line.
Yes.
To provide flexible framework. And instead of provide latitude, simply say allow. So that after the comma it says, but the flexible framework does not allow the grandfathered LRE to move further from compliance than it was on May 8, 2001. Isn't that what it should say?
Yes.
Mhm.
Okay,
Okay.
does not,
But the flexible framework does not allow the grandfathered LRE to move further from compliance than it was on May 8, 2001. And what we might want to say in parentheses, quote, no backsliding.
Or maybe just say that this
Or
is what has been
described
referred to in the record
as,
as no backsliding.
yes. Do we need to add a sentence to that paragraph that says that all proposed additions must comply with code?
No, we say that.
Or have we said that already
That's
someplace?
We say
I
that.
think that's in a
14.
conclusion, right?
14 says that.
Oh, okay,
Oh,
yes,
conformity.
You're right, you're right.
14 bullet, the
Yes,
the
yes, yes, yes.
C bullet,
Correct.
or C or D.
Yeah, okay. Then we are turning to the next page, because number 18 we've covered already. And we are now turning our attention to paragraph 19.
Before we get into 19, do we need to take a look at 2155.100, where it's another admonition. Where
2555, 100?
21.55.100.
That's non-conforming parking facility, loading dock signs or other characteristics of use?
Well, it's really referring, actually, it's 2155.010, where you're talking about non-conforming uses. And again, that intent there is,
Which section are you talking about now?
2155.010, intent,
Zero,
where this is talking about
I
non-conforming.
don't have that,
010.
don't have that.
And here's one.
Why don't I have that?
2155,
Oh, 010, okay, intent. I see, I'm sorry. Oh dear.
It is the intent of this chapter to permit these nonconformities to continue until they are removed, but not to encourage their perpetuation. Further intent is that conformities shall not be enlarged upon, expanded, or extended.
Right, but the problem with talking about that is that the LRE site plan amendments are specifically not to
They're not.
be treated
As
as
non-conforming.
non-conforming. And so the standard for no backsliding, if that's what you're talking about,
Yeah,
is not derived from that paragraph.
okay.
But I think that your point is well made, because the paragraph that is, no backsliding is derived from is 2150, 200. And those are the general
2150, 200.
conditions of site plan review.
Yeah.
And so all projects, all sites, if it's gonna either be, project's either gonna be non-conforming or it's gonna be site plan review. I mean, that's the two things that would apply here. We know that it's not non-conforming, so if it's a site plan review project, then you
Oh, it's
have-
deemed conforming.
It's deemed conforming.
Yeah.
But that's in
Okay.
130, but I think it's important for the board to maybe important for the board to mention 2150, 100, if I have that right,
No,
which is,
no, that's the off-street part.
no,
21.
5200?
50,
5100, oh, 5200.
general standards for site
Yeah,
plan
yeah,
approval.
yeah.
Yes,
that's
okay,
it,
so
that's it.
that is a key
Yeah.
element here, because what happens is, for in any site plan review, including these ones under 320, the provisions in 320 and 2155, 130 applying 320 are specific conditions for this type of thing, but it doesn't exempt them from the general conditions. So how Title 21 was set up, you have general conditions for conditional use, and then you have specific ones like this one that we looked
Yeah,
at
yeah.
for parking.
And it's for the entire title, 21.
Yeah, it's for
For the
anything
general,
within title,
yep.
within the land
Yeah.
use code. So here if you're going for a site plan review, you have general conditions to meet, and then you have the specific ones that are specific
Yeah.
to the type
Yep.
of project that you
Yeah,
have.
gas station, gallery.
Right,
Yeah,
right,
yeah.
right.
Or these other
Cemetery.
characteristics of use,
Yeah.
parking lot and all that. So in the overarching, or, the main thing that applies to every site plan review is staff has to make a determination, that's in code, that the amendment, the site plan amendment in this case, generally meets or conforms with, complies with everything. Well, they're okay about the big project as of May, because as of May 8th, 2001, the big project was deemed approved, as you just were talking about. But the new site plan, whatever's proposed in the new site plan amendment in 2014 isn't deemed approved. So anything that doesn't meet code, current code, which is 320, it has to have those what I kept calling mitigation factors, but the 5
Yeah.
considerations apply to them. And because staff has to say the whole project still meets code, it can't backslide, but only the project as it existed in 2001 was deemed approved. If a site plan amendment comes along and unravels
Yeah.
the compliance as it existed in 2001, that's backsliding, and nobody can make a determination that it still
Yeah.
meets, because the deemed only took those parts as it existed in 2001. Does that make sense? Have I explained it right, I guess is what I'm,
Yeah.
I mean, is my understanding
Yeah.
right?
Yeah.
With it?
No, that's
Am I
correct.
expressing what you
So
understood?
the question is, do we need to make any reference to that or not?
I think that that's a good idea, because I had thought that, that when we were talking last night, that 2150, 200 was talked about. And I thought that the only discrepancy was whether it was 100 or 200.
I think we did mention that.
Yeah, and we just didn't know what, and I didn't, we were in the latest at
So
night,
what would you
and
like to do? Would you
So-
like to add a sentence to 17, is it 17? Which will be renumbered as number 15.
Well, or it says in our C bullet or whatever it is, the Belinda site plan amendment is required to maintain conformity with code under 2150-320, 2150-200. So we do have that.
We
in
do
there.
have that in there.
Okay, that's
And
good.
as provided by the mitigating circumstances of 2155-130. So
Yeah,
I think we're okay.
Okay.
I
Well,
think
could
so
you,
too.
could you say it just, and further reinforced by 2150-200?
Well, 2150-200 is in there.
It's already in
Oh,
there.
I'm sorry.
I mean, he
Yeah, it's
said
already-
I didn't
it's
hear
in the
that.
bullet, and so the question.
Oh, it's in the
we have
bullet.
that bullet
Yeah.
up there, and so now we come to 15.
Okay, I didn't write that in mine.
It's in
Where is
there.
it?
Oh, it's in there.
It's in there.
The old number 15, just read through the old number 15.
Oh, I'm in the wrong, okay.
Old number
It's-
15, and now we're talking about.
it's already
new
there.
number
Yes.
It is already there. So I think we are fine.
Yep, I think we are too.
Okay. Can we put that to bed? Does
Yes.
this work? Okay, then let's go to 19. I would like to reword that slightly, so that the beginning of the sentence reads, the tendency of, the pending litigation between the applicant and others in federal court, comma, the assertion that site plan amendments violate CCRs, comma, does not empower the Planning and Zoning Commission or the Board of Adjustment to opine on the merits or to render any decision regarding it. And then simply follow with what's now number 21. Disputes over CCRs are non-jurisdictional to the Planning and Zoning Commission and shall not be considered.
If we spelled out CCR in
Yeah, I would
this,
spell out CCR. This, literally, this was.
I know, that's,
528.
that's
you know,
our
so at some
shorthand.
point I
Got
had
it.
to say,
In
I
fact-
somebody would spell it
Okay.
out.
Yeah, would you?
I'll just take that from but I'm not quite sure that I have this, and there's one point about this that I wasn't so great at explaining last night, but as I understand the issue about this that's raised by the appellants isn't that this board or P&Z should opine on the merits. And the other thing about that is that I think it would be helpful to reference so 2 points about this. One I brought up last night, but not very well, and the second one I'm bringing up new tonight. One is the appellant's briefing attaches.
I
That-
saw that.
Okay.
Let's just disregard that. I think we just disregard it.
Okay, well,
Oh.
you can. I think it's a decision. I mean, I think it's a
What?
decision.
What is the issue? I don't-
There was a page attached to the reply brief, I think. Let's take.
Yes, I know what you're talking about.
It's the actual court's
and my-
decision. Yeah, it's
yeah.
the actual court's decision. And so I went ahead and read it. What's helpful
I
to
haven't.
me about it is that the court, right in the decision, says that it doesn't give the P&Z jurisdiction. And as the court explains, and I think that this is true, that if there had been a decision on the merits about that, so the court came down and made a decision and said something to the effect that this and this and this and this are prohibited under the covenants, then that could, then that decision is something to be, these are my words, the Planning and Zoning Commission does not wish to turn a blind eye to. You don't have to park your common sense at the door if somebody's waiving a decision on the merits. It's not enforcing the covenants, but if it said that something that P&Z was telling them to do was actually illegal under a federal ruling, it's not Xing it out. So they're not really asking what was attached flies in the face of what the appellant was actually asking P&Z to do. Because the appellant was asking P&Z to be influenced by assertions. And the federal court record, federal court decision that's attached says that's not a good idea. So, anyway.
So, come back to 19.
Okay, so you have the pendency, I have so far dependency.
No, the pending.
Pending, I misread my
Pending
I scratched out
litigation.
the pending litigation between the applicant and others in federal court, comma,
The assertion that site plan amendments violate CCRs, comma, does not empower Planning and Zoning Commission or the Board of Adjustment to opine on the merits or to render any decision regarding it.
regarding it.
Yes, it, the
pending
assertion,
Regarding
the assertion and the litigation, it.
Regarding it, well, those are two things, but I'm gonna go ahead and do exactly what you said.
All right.
It.
So we'll see what happens.
Okay. And then you're gonna combine the dispute and add that
And
sentence.
simply
in there.
add that as a sentence.
Yeah.
A dispute over CCRs is non-jurisdictional to the Planning and Zoning Commission and shall not be considered. That make sense?
Yes.
Okay. So now then, we have an issue that we parked from beforehand, and that has to do with a procedural problem with the resolution, with the P&Z resolution. And it seems to me that we simply should add that as a finding. And in general terms, I mean to add a sentence that says there was a procedural problem with a decision in any event. And the question is whether we need to describe it in excruciating detail. Remember what the problem is, number one, that there were no findings that were verbalized or referred to before the motion to approve was made. What else was there? Wasn't there a second
There's two things.
second
So-
deficiency?
Yeah, the
The
whole
eighth.
adoption from the record is incomplete. One thing that you might want to say, whether you noted or as anything, you could say that I would be thinking that the Board of Adjustment notes there are procedural problems with the planning and zoning resolution 201-602. In that the motion supporting the findings,
No, the motion adopting.
the motion adopting the planning and zoning decision, or what?
Or approving. approving the application.
Okay. Approving
Approving,
the application. And the wording or something of the resolution.
what are you trying, Dave?
What I wanted to say is that you noted that the record on appeal, or the record before the Board of Adjustment was inadequate to show that the resolution, 2016-023, was adopted by, or was approved by the motion, and that the record is incomplete to show that the resolution as drafted was adopted by the entire board.
Okay, so that's one thing you want to say, and that the resolution approving the application was not contained in the record on appeal.
No, the resolution does. It's not that the resolution is 2006.
No. There is no evidence in the record that the resolution was ever adopted by the full board.
By the full board,
By
yes.
the full board.
That's one thing right there.
What do you mean when you say the resolution was not adopted by the full board?
The motion, no.
No, I'm not-
The full resolution was not, there is no evidence in the record that the full resolution was ever adopted by the board. Remember, there's only a signature of the chairman on there.
So the record, they had a lot of
Okay.
trouble putting this record together over and over and over again. And so one of the omissions that is still present
Okay.
is that the record, before, as it appears before you guys, there is no evidence in this record that the full board, that the Planning and Zoning Commission adopted.
Okay, so we
the resolution.
would need the minutes of the following meeting or
Right, but what
August.
you would say is you make these two things that I think that you
Got
want to
it.
make, and just say that because it's remanded, the board, you're just pointing it out so that on remand they can correct that. You don't have to do anything else about it, but why not note it so that they can make the proper corrections? And so that what you guys were talking about last night was something, you talked about that, which is one point. The other thing that I understood you to be saying is that there is somehow a disconnect between the motion in the record
That's, yeah.
and what's reflected in the motion doesn't match what was reported as being approved by Planning and Zoning. So that goes to the approval section. Those Planning and Zoning
So,
resolutions have this funny two-part thing that's a little bizarre as far as I can tell. But one is that the one ending paragraph said this is what was adopted, as of on the date of the public hearing, and then this is what was passed and approved on the as of the passed and approved by P&Z on July 11th, and then it says and it was adopted by P&Z on October, and so the record is incomplete in
yes, got it.
Both of those.
Okay, now, do we want to say something about the findings, Dwayne? Tell me.
Well, I think that
Remember
we
putting the
should
cart
address
before
that.
the horse?
Because we do have language now that says, despite lengthy public testimony, all findings remain virtually the same, with the exception of one addition, two conditions relating to sidewalks and signage were added. So we do have that, so we developed that discussion, and we could say, if we wished, we could probably add to that a statement that the approved resolution does not seem to correlate with the findings or the
motion.
the motion and discussion within the court, the record.
Oh, we could say that at the beginning. Yeah. I think
Because I know there's things about site plan, conformity, moving, Spring says something, Robinson says something.
Well,
Sport
Robinson
is
is pleading.
None of that discussion is
Yeah.
in that. I mean, those were all possible basis.
Yeah,
for
but
the
they should have been
resolution.
made beforehand,
Well,
before the
well,
motion
some of them were-
was voted on.
Yeah, well, they like to sprinkle it up here, it appears. So
Is that
yes. they should-
customary?
What's that?
Is that customary?
No, I've not seen that.
I have not seen this either. So I think we ought
No.
to mention this.
Show me
I've
where
not
we are on
seen
the,
that.
where are you on
In the record?
that you're-
No, page 130 is kind of where the motion, that's where Commissioner Sporthays makes his motion. Page 130, he makes his motion, but he doesn't speak to it. Then he asks him to speak to it, but for some reason Walker speaks to it, which is, would you like to speak to that motion, Brandon? Commissioner Walker. So I don't know if it was Walker or Sporthays, that confused me. And he says, well, it's a tough decision, we're bounded by what we have the authority to do through the municipality, through our appointment here. Was it missed? Perhaps. I don't understand quite what he's saying. The title, new Title 21, which we aren't even being judged by, intended quote from the commission, so it's a rambling thing that doesn't provide any basis of fact. But he does finally say, which I get lost in the site specific, and so instead of, providing finding of facts, his conclusion is, but if you look at the other malls, and that's the one that really got me, was you look at the other malls, that's not the standard. The standard is not the Diamond
Right, that's what
Center
you were talking
or
about.
Anchorage
So
Fifth
that-
Avenue, that's what I was
Yeah.
talking about.
Okay, so
Well-
let's. I
So
think
there's
it's
nothing
good
there.
To pinpoint that.
Well,
And that whole discussion's on 131, that top.
Well, what I was getting to was that they voted, look at page 134, motion carries.
And then they asked, then Mr. Spring
and
started
then-
talking.
And then Springer talks about, well, this is why I vote. The whole thing is kind of, so I'd like to make a finding. So he suddenly wants to make a finding after the motion has already carried.
And I've not ever seen that happen before.
And that should have come before they voted.
Well, he should have made the case for
Yeah.
the specific conditions of approval, and there should have been, there are certain standards, and they should have gone down those standards and say, we find this in conformance because it does this. We
Yeah.
find it in conformance, for example, they may have stated, and this would have been very useful and could have thwarted much of this discussion, if they had simply stated on the record that they find that sidewalk satisfies the requirements for pedestrian
Exactly.
connection in a safe and responsible manner. They never say that.
No.
And if you go through that, there's words like something to the effect of, well, I guess they did about as good as they can do, and as good as anyone can do to mitigate any kind of safety concerns that we have as a commission. That compared to other malls or pad sites. And so it's just, that's conditions of approval each have to be justified and the standards have to be compared in your findings. That's the way we did it. That's the way they need to do it. That's the way the code requires them to do it.
Absolutely.
Pretty
So
simple.
do we want to address that as an admonition?
I think that admonition probably.
Well-
I think it's a procedural issue that should be addressed. Findings are made after the motion was approved.
So that's one aspect.
Which appears to, and I would say in an effort to appear to justify the motion and the vote on the motion, and it's not an appropriate way to do business.
Okay, so what we should say, furthermore, findings supporting the motion of approval.
Well, just findings made, it's not clear even that they support the motion, so findings made after,
After a vote has been taken.
And, he says motion carries. Are there additional findings? Go ahead, Mr. Spring. And so I don't know if this is the way they do business or not. I used to go quite regularly. I don't remember that happening before.
No.
So I hopefully this is not the way they do business, but it may be a standard of practice now. I don't know.
I would find that really inappropriate, because what you do is before the vote is taken, you refer to findings of fact. The findings of fact supporting this motion are the following: statements made by John Doe and Jane Doe and et cetera, and now please vote.
And you state that so that the other commissioners can make
Exactly.
their mind up. I mean, some
Exactly.
people are up on
So
the
you
fence.
do that before you vote, not after you vote.
Yeah, I mean, a lot of commissioners, I would say probably half the commissioners on any given case haven't made their mind up until they push a button. So, it's sometimes the way it works. So that's why you make findings before, so that you can state why that this makes
Okay,
sense.
furthermore, findings supporting,
I
supporting.
don't think that it should say supporting, because you've already said that the findings don't support. And so, that there's a disconnect, so it's findings were made at, but
I think you could say, procedurally, there was procedural fault in the fact that findings were requested after the vote,
yes.
which, and
The
I,
procedural fault, procedural fault in that.
We have already said there are procedural problems,
Wait.
so why don't we simply say
I just want to get
furthermore,
his thought down for a second here. Procedural fault in that findings were
requested after the motion had been voted on.
Were requested
And received.
and received after the motion
Was voted upon.
was voted, the motion to approve the
the
application.
motion, the motion
Approve,
to approve.
Motion carries. Are there additional findings?
No, just to
And I
to
think,
approve,
and what
the
I,
application.
to approve the application.
and, I don't know if we want to say
Had been
this.
voted on,
Yeah.
had already been voted on.
And I don't know if we want to say this, we might discuss it, but leading to the possible perception that the commission had made up its mind and was trying to justify.
No, I don't think we should say that.
Yeah,
I
okay.
know, so I think here's the paragraph as I have written it down. There are procedural problems with resolution number so-and-so, in that the resolution approving the application was not contained in the record on appeal. Furthermore,
What does that mean, the resolution approving the application?
That gets back to the fact that we have no record of the board having voted, the commission.
But that's not what
having
that says, and so I'm reluctant to go with that.
approving the application. The resolution approving the application.
Well, that's a problem with our staff packet. right? That's not a problem with the commission. Staff package should have included that.
Yeah.
Because there
And
And
is,
we need
it's not
to-
necessarily a resolution, it goes on the consent agenda, as you said, and they.
well, it's a
approve it.
resolution. It's in their packets.
It's a resolution to approve,
No,
Yeah.
what they have is a stack of resolutions. Let's say they passed 5 cases last time.
Right.
They have them all right there with the staff.
and one of those would have
Draft.
been,
Yes.
would have been planning and zoning resolution 2016
Yes.
029.
Yes.
So it's not true to say that that's not in your packet. What's not in your packet, because, I can show you the record here where it is, we have that resolution.
No. No,
Well, we
don't.
have the
We
resolution.
don't.
What we
It's-
don't have is the record of them voting on it.
Yes, that's right. You don't have the record of them
Right.
approving this resolution.
Right.
And so
But-
that would be the minutes from the following meeting, the August meeting.
Or whatever they had, but it
Because they
wouldn't
would
say that
show-
it's the resolution approving the resolution, or wouldn't say the resolution approving the application. You have in the record the resolution that approved this application, that's what you're arguing about.
No, that's not what we're arguing about. What
Yeah.
we're arguing about is the fact that there's nothing in the record that shows that the resolution was approved on August the 8th or whatever.
Right,
the
so then
magic
write that
date
down,
is.
but that's not what you just said,
Yeah.
what you read out wasn't that.
Yes, in that the resolution approving the application was not contained in the record on appeal.
But it is, the resolution approving the application is on the record of appeal.
The board documentation of action by the commission. I think those are the words you want.
I don't know, but I can tell
Okay.
you that those words
Okay,
aren't
all
it.
right.
Yeah, it's in the
So
record now,
sensitive.
Yeah, it's in the record now.
but it's not connected.
We don't
It's
have
not
a
supported.
record of it. We don't have a record.
Again, what you don't have
Yeah.
a record of is that the
Resolution.
commission approved the resolution that it is, that the commission adopted. The back of that resolution says that that it was adopted. And you don't have anything in the record to support the adoption. The adoption of resolution AR 2013 -29.
We have this,
Resolution
but we
adopted.
don't have the documentation that shows that they did
Right.
this.
The record doesn't reflect that resolution 2016
Okay,
Vote on it.
Right.
29 was adopted by
correct.
the Planning and Zoning Commission.
Yes. There's a procedural problem in that the resolution adopting the resolution.
There's no
Was
resolution
not
to
con-
adopt the resolution.
Yes, there is.
No, they don't. They put this resolution on the agenda. And if
Right.
it's not pulled on the agenda, and the consent agenda is adopted, there's no resolution to adopt the resolution. There's this resolution, it goes, just like with the assembly. The assembly can have an AIM, it goes in front of the assembly. If they don't do anything, the consent agenda is approved. That's the procedure.
Yep, that's it.
In lieu of the formal resolution, yes. So there's the consent agenda.
Okay, I need to take
but-
a break, because you know what? It's not making a bit of sense to me right now.
Okay. All right, let us forge ahead and take a look at formal requirements. Do you have in front of you the previous resolution that we passed? The one that was appealed to the Superior Court? And the reason that I want to simply
Yeah, I
refer
have that
to
right
it
here, which
is
is
because there is what I'm considering,
page 21.
yep, 21 through 25. There is, at the beginning of that, a lot of what I call the boilerplate. And I think we should quickly take a look at that. Julia pretty much, so let us look at the draft that we have been considering and compare that to the first page of our previous decision. Whereas on May 14, an application is filed. Rules of appeal. I'm not sure. I'm looking on page 2, the second whereas. I'm not sure we need to have that at all. What is your thought?
I didn't know what it added. I had a question mark, but I mean, I guess it states why we're here, that there's
Well,
an appellant,
yeah,
and
but-
there's certain.
No, we are here because there was a notice of appeal filed. Huh. I would suggest that we strike that second whereas on page 2.
It's the appellant's assertion.
I don't think we need to talk about that. So, Bob, are you in agreement for that?
Yeah, I don't think it really adds anything.
No, I don't.
The only
It's-
reason I could assume it was there was a boilerplate issue, that you needed to state that there was an appellant and what their issue was.
I don't think we need to do that.
It's the assertions of the appellant. Well, like I said, it doesn't make any difference. If we would talk about that, then we probably should talk about the others, but that's further on, but that's later.
I don't think we need to.
I think what we're doing is we're setting the chronological happenings and putting them in here so that people can get an idea, or the review can get an idea of what actually transpired when. And I went through those dates, they're all correct.
Okay. We have another, thank you for closing the door. So So I think we are fine as to that. Then we turn now to the very last page of the proposed resolution, page 8. It says conclusions once more. And while I think those two sentences are important, they follow our direction, and I don't think they should. So I think those last two paragraphs on page 8 should simply go elsewhere.
Well, they're also called conclusions, but on page 5,
So
the title is also conclusions, so.
yes, so why don't we simply put those ahead? And put number 1 and 2 as the first conclusions, ahead of what has been renamed as paragraph 5. That make sense to you?
Either there or whereas language, whereas an appeal was heard in accordance with 2130-090, was held in accordance with 2130, whereas it was held in accordance with AMC
Is
2130-080.
deliberated. Oh, you're looking at the very last whereas clause that we have, deliberated the appeal.
Well, in the past, we've used them under conclusions.
So we usually put them under conclusions, so it should be the first under conclusions.
Well, that's what
first.
I'm, yes.
The chronology is in the beginning. I like the idea of adding them to the conclusions in the beginning.
So in lieu, ahead of what we have renamed paragraph 5?
Yeah, that would be ahead of paragraph 7. The old 4.
Huh.
Oh, that's right.
Ahead of, wait a minute. Where do we stick it? There is the large section that's entitled conclusions,
Yes.
okay? And these two paragraphs that we are talking about on page 8 should be the very first conclusions.
Right. So they would be 7 and 8. And then the old 4 becomes 9, etc.
We added some findings.
We did.
Okay,
We
we
had-
added findings 4, 5,
4,
and
5, and 6.
So this would be paragraph 7 and 8, correct. And what's presently printed labeled as number 4 should become number 9.
Mhm.
The next one becomes number 10, then number 11, 12, and that's it, because, nope, there is a number, and look at the top of page 6, what is labeled number 9 should become number 13.
Number,
See that?
Yeah,
9 moved
that
to-
became a finding, didn't it?
9 moved to find number 4.
Oh, that is number 4, okay.
And so then 10 becomes 13.
Mm-hmm.
Or no,
They're,
No. I have finding number 4 is what's listed as paragraph 10. But we combined those, didn't we?
Yeah, I'm not sure.
We combined the first part of 10 and that was combined with the printed 9.
I thought so.
Yes.
So
yes.
that's finding 4.
Yeah,
Okay, so that was combined.
yeah, that was.
Okay, so we are simply following what we now have relabeled number 12. There is the paragraph that has no number on it. Pursuant to AMC 2130-090B, the Board of Adjustment exercises its independent judgment on legal issues, et cetera, and provides direction as follows. And then we should start out with number 13, shouldn't we?
Correct.
Isn't that, I think it should be 13, the one you just read.
No, we were not going to number that.
Oh,
We
okay.
took the number off.
Okay,
Right, the one that says pursuant to AMC.
Yes, we
Right.
took the number off.
Right,
okay.
it's just a standalone paragraph.
A standalone paragraph, and then we had a series of directives. And the directives started with is it with number 13?
That would be the next number.
I
No,
think so.
That was B. Where was A? There was an A somewhere.
We are having trouble reconstructing the number.
Well, I wouldn't worry so much about reconstructing the number yet. I mean, we have to put all these things in there, and they'll come in the order,
Okay,
and then.
I just want to
we'll do
be
it.
sure that you can follow all of the, see, look at my notes here,
Yeah,
that you can follow all of this when you put this in final form tomorrow.
right.
That's the only thing I'm concerned about.
Right, but I don't know that reconstructing the numbering is gonna.
Okay,
be the thing
all
to
right.
Focus on, but I do wanna catch up wherever, whatever you guys came up with.
Okay,
For the, procedural. My understanding was you just wanted to make some kind of a note, it wasn't
just
the
the
issue
directive.
because, and it was sort of in the sense that you kind of made these mistakes here, we're sending it back on remand, just don't do it again. Something
Yes,
like that. So-
correct,
So.
correct.
But not, it wasn't a major issue
No,
at this point because there are other larger issues that you've already addressed.
so, but it's the last one that we are really addressing, and so we might as well say, and while we're at it, there's a procedural problem here. So, wait, do you want to leave off, just to see if we can come to closure on this, all this stuff about the consent agenda, just leave that off and simply say the findings were requested and received after the motion for approval, to approve the application had already been voted on.
Yeah, okay, so let me write that down.
Well, he requested 3 times that they make findings, and then he asked for findings yet again after the chair did it.
Yeah.
After the vote,
And there were 2 that were made after the,
Right.
yeah, Mr. Spring
in Walker.
and Walker did, yeah, that's right.
Well, I guess,
Is it worth addressing this at all?
I think
You
the
know-
part I think a different part is worth addressing. Yeah, because the situation that you're having here about the findings in the motion, to the extent that they made any findings, were ahead you know, and so they have to go back and redo it. What I thought that the comments that you wanted to, I understood from last night anyway, that the comments, and I'm sorry that I just didn't get to them here, that the comments were that the something to the effect that the motion, and I was focused on the motion rather than a motion in the finding situation, that's something new tonight, but that the motion to approve the site plan amendment in the limited site review did not reflect the sum and substance of what is contained in planning and zoning resolution 2016-029. So that was one thing that you talked about last night, and why you were saying that it wasn't a major issue is that you were going to be sending it back to have a redo anyway, basically. So, but that was one, and then the second one was that the record before the Board of Adjustment in this case does not include evidence of adoption of planning and zoning resolution 2016-029. Now, you're not saying that it wasn't, you're just noting that the record
Right.
here, doesn't.
Correct.
Doesn't,
Is it- Yeah.
include.
Is it worth addressing that, or should we simply leave that alone?
Well, I think that those are things that you spend time looking at, and now you don't want them to
Okay.
do it again on remand. I mean, that was where I thought the whole thrust
Okay.
of that was
Okay.
last night. It could be by footnote if you didn't want it to have it be as prominent, or you could do an introduction. You've done findings and you've done all that. You could just have, say, two. The board adjustment notes also the following, and it makes no anyway, I don't know what you want to do about it. It seems like there's a couple of things there that there'll be a place to.
Well, should we address it? Is it worth addressing?
Yeah, my concern about that is we're giving all this very specific direction to the commission.
Yes.
And now we're talking about a default in the record. Well, the commission's not responsible for that.
No.
I mean, that's worth a note to Hal Hart and say, hey, Hal, if the record wasn't complete. But
I think we should leave that.
My fear
alone.
is
I mean, that has been addressed
they'll get confused.
sufficiently. But should we give them some admonition that findings have to be made before the motion is voted on?
Well,
I think that's,
my concern, yeah, I think so. And the primary reason is, I think it looks like they're trying, it makes it appear as though they're trying to justify their action after the fact.
after the fact, yes.
And that's not good public process.
Okay, so. we
Make your
should-
case and then make
Okay.
everybody agree that what you said is correct or not.
Yes,
And if they do agree with it and they vote for it, then they agree with what you said. But to make your case afterwards,
is,
it appears you're trying to justify your action
yes.
without stating the case. I mean,
So
it's
do you
fundamental
think that's
process.
worth talking about?
Okay, I'm just going to read what Dean says.
Okay,
record needs to be supplemented with evidence of the actual adoption. Okay, you could say in the future, so he's still responding to that, in the future. So, okay, so that's on that one. What I took notes earlier tonight in Dwayne's discussion on what you're talking about now. And let me just find it, because it seemed to me that that was something that you were going to come back to, and maybe that's exactly where you are now, and it is,
Yeah, and my question to you is it worthwhile talking
I think so,
about?
because what it does is that it, give me a second to find my notes on what I said to,
You took too many
put
notes.
down. Well, these are all the early ones. I haven't took any other notebook. Well, I don't see the notes, but what Dwayne was talking about was, and he showed us the transcript here, and he said that, I can't find those notes. He said that they talked about things that, like the downtown mall, or other things, and that.
But you look at other malls, other pad sites, people get out in traffic all the time.
Yeah, and that they said approximate, that they just done good, about as good as you could. And that the problem there is that there are standards that need to be applied. And that, that even if you had everything else procedurally correct, the rule is that you apply the standards, not talk about, well, it's against those who's against.
It would still be the 1950s.
Yeah.
Everything would look like
And-
4th Avenue 1950.
But I think we addressed that general subject matter before.
I think you did before, and I think that what
And-
Dwayne's examples do, is, in your own opinion, make sure that the conclusions and the findings in the record are all kind of tied together. It gave some specifics to that, and so I was thinking that would be a good place to make sure that those were covered.
So there's two issues, I guess. One is the comparison shopping thing, I guess, if you can call it that. Comparison shopping mall.
Yeah, because there was reference to power centers. There was reference to, well, in this case, we can't reorient the store. So, but there is a lot of references to what downtown businesses encounter and what treated this as. You mentioned power
It doesn't
centers.
matter, but it doesn't matter because downtown has its own zoning classification. There are completely different standards.
Yeah, they're not
It doesn't
alone.
matter. We aren't comparing it. And, in all honesty, staff took them down that road. Said, well, they walked
Okay,
downtown.
yeah, but do we address that by way of directive or not? That's
No, I
really
think it
the
goes
issue.
back up to someplace in the findings. I don't think it goes down here under the.
I would agree
Under the
with
directions.
findings.
I
Okay.
think that those were
Sure.
examples, and the same, and I also think that about the other minor aspects that you were talking about, that they're not really in the directive category. They're just gaps that we can.
That we noted.
That we noted, and then in this one, that
So-
Wayne was talking about, that goes to, probably goes to one of the things that we,
So would you like to add that to one of the findings?
yeah, so let's look and see. Medicaid findings. Yeah, so I think it goes under your findings 3 and gives, you had at the conclusion, this is early on. At
Okay.
the conclusion of the public hearing, well, let's see, so far it says at conclusion after deliberation, the planning and zoning commission did not provide findings of fact and conclusions sufficient to document the proposed
Proposed
site
site
plan
plan amendments.
compliance. Okay, so then, sort of following that is something that says that, okay, so let's see, what do we have already that we're putting into a finding?
Well, then we are talking about the planning department memorandum, and we are talking about the 10% cost of compliance.
In the findings, so between those two, between this subject about sufficient to document the proposed action, then something,
Would you like to add it to paragraph 3?
I just think it's a separate paragraph that fits nicely between paragraph 3 and and the next set of stuff, which you just said what that was.
Right,
So
right.
I don't think it falls into paragraph 3, but I
Okay.
think that it's in keeping with what you're doing here about the findings. And so and Dwayne was talking about, and Dwayne, I'm just so sorry that I can't find, I was holding things up so I could write it down, and then
Well, let me just offer some language here perhaps. To the extent facts were provided, or findings were provided, you could say some or many were after action on the motion was complete. Leading or providing the appearance of justification of a fait accompli or something.
I like all that. To the extent findings,
Were-
just to get it down, were provided.
Some were
Some-
offered
Some were offered
after,
after action was complete. Action on the motion was complete.
Offered after action on the motion approving the site plan amendment was complete.
And I don't know if we want to provide a suggestion, but providing the appearance of justification.
giving the
Okay, so you
appearance.
could
Giving
say
the
this,
appearance.
you could say, you know, this is a finding, okay, so you could do that way, or you could have the next sentence be, this procedure runs the risk
That's right.
of creating, and then what did you say?
An appearance
Creating an appearance
of justification,
of justification
say for fait accompli or for
after the fact justification.
Yes.
That works, yeah.
After hyphen fact.
Okay, so then what about the second prong of that, which is the application of standards? That is the
Much, I could say something, in deliberations, conclusions were drawn by comparing the application, the site plan amendment application against other similar LREs.
Try that again.
in deliberations.
Deliberations,
Conclusions were drawn by comparing the site plan
amendment in comparison
we already got comparing the site plan amendment application
to other
to
LRDs.
other LREs, instead of.
Right, instead of adhering to the conformity requirements of 2150, 100, 2155, all of our,
Okay, instead of applying the standards,
what title?
the standards in
2150, 030.
2150, 200,
Yeah, always.
2150, 20, and 2155, 130.
Did you get the, could you read that again?
Yes. So in deliberation, or I would say during deliberation, conclusions were drawn by comparing the site plan amendment application. Again, anyway, say
By
before me and say
comparing.
by comparing the site plan amendment application to other LREs, to other large retail establishments, instead of applying the standards in 200, 21, 50, 320, and 2155,
Yes.
130. Okay, and then there was something else that Tony was talking about in that, and that was, okay, so that's, you look at other malls, other ad sites, people get out of traffic. It had to do about that safety is why I did it. Oh, the business is about as good as anyone can do to mitigate the kind of safety concerns that we have as a commission.
Yeah, safety concerns we have as a committee, I don't even know what that means.
So we can just reference 131. I mean, did the board want to say anything about safety?
Well, that's in the code. It's-
I agree.
As architectural, safety provision, I'd rather not get into a value judgment. I don't know that they're going to say, no, it's all going to be interior, that anything exterior moves away from.
Right.
We aren't there.
Okay,
I mean,
all right.
it may well be appealed again, and maybe we have to then exercise our,
Right.
Next time.
So then
But-
the last two things that I had, did we cover everything that was in the parking
I think so.
lot? Okay.
We have,
So-
yes.
So the other 2 points that you talked about last time, and we talked about a little bit today, and before we got,
Yeah.
but I don't think I know exactly where to put them in, but it seemed like they were important, were those 2 points that Dwayne made,
there was.
the public hearing, the non-encouraging dialogue takes out the party's ability to negotiate and, did we talk about that?
We did.
Okay, all right.
We-
then I'm
we
good.
have
Then
that.
I just don't have.
Do we
Yeah.
have that?
Yeah, we have that
There's
somewhere.
one in,
Yeah,
That's one
we
of our
addressed that.
amendments.
Yes.
I remember talking about it.
Yes.
Yeah.
No, we
I
have
was
that
just thinking that I
someplace.
put it in the parking lot. and
I
just-
th-
I
I think
we-
that's, I think that's number 5 in the
I think
findings.
so. I think
Is
so.
number 5 what?
Yeah.
Oh,
Number
that's
5 in
right.
the findings.
It's not here because I got it over here.
limited productive dialogue among
Yes,
concerned,
Yep.
all concerned parties.
yep,
Okay, good,
so we have that.
okay.
Okay. So, these are two additional findings that I hear that you want to add. And the question is, so that Julia has an idea where to stick this when she puts this together, is that it should follow finding number 3.
That's what
I think that's what we agreed on.
That's what we agreed on. So that should be 4 and 5. Agreed?
Yes.
Okay. And then what we have now labeled as number 4 becomes number 6.
You're right.
That becomes number 6. And where is finding number 5? I'm trying to find that. Help us out
New
here.
5 or?
It was an addition.
It is an addition, and I'm just trying to,
What is this?
here.
Here.
Okay.
Those were two.
I have it, okay. So what is number 5 becomes number 6. And what is number 6 becomes number 7. Okay, so we have 7 findings.
Mhm.
Okay, so, now you have to go back and help me find
Okay,
5 that you just
okay,
found.
number 5, we just addressed that. What was number 5 is now becoming number
Right.
6.
But I want to
And
know
that
what
says,
was number 5, yeah.
the planning department's interpretation of applicable code sections limited productive dialogue among all concerned.
And we added the word erroneous.
Yeah, I think productive dialogue.
Erroneous interpretation.
Help me out, where was that? In the sentence that I just read?
Yes, right in the very beginning. Planning department's erroneous interpretation.
Erroneous interpretation of applicable code sections limited productive dialogue.
Okay,
You have that.
yeah, okay. So.
So that's number 5.
Okay, so planning department's erroneous, okay, got the erroneous. Okay, so that was number 5.
5 and is now number 6.
6.
Okay.
That's new 6, okay.
And what is number 6 becomes number 7.
Okay, and the one that was number 6, I had it here for a second, and it was
Using-
Old 12,
Old
Yes.
12.
abbreviated.
Correct.
Yep.
Okay.
Okay, so I think.
And then what's finding number 7? You said we had 7 findings.
Yeah, that's
So I got to 6,
that's the printed number 12
is number 6.
is number 7.
It's now 7.
It's now 7.
Okay, so
How in the world are you going to?
we
Maybe-
did a policy. Okay, that was 6 and this is 7.
Yeah,
Okay, I'm
maybe
good.
you and I need to get together tomorrow.
Right.
So,
Right.
so
There
Yes.
were these two things. on
yeah,
this.
well, I'm coming to that right now.
Okay.
Okay, Julia, regarding what's on page 8,
Okay, what is that page 8?
the 2 paragraphs.
Oh, yeah.
Okay, we added those at the very beginning as the first conclusion. Where it says, you know, the big heading, conclusion, we simply added those. So those should become paragraphs 8 and 9. 8 and 9. And then we proceed from there. 9, 10, 11, 12, 13. So we have 13 conclusions.
Okay,
Does that comport with your understanding?
It's 9.
Then,
11.
Oh, Julie, you need to see
then,
incredible.
what was,
What is,
when we started out tonight as 4,
becomes number 10,
is number 10.
and then it follows down to 13.
Okay,
13, and remember what originally was number 8 is just the introduction to directives, so we did not number that. Okay? There's no number on it.
old 8,
Yes. Old 8 has no number.
okay.
And then we have a bunch of directives. And that starts out with what was labeled number 13, and I think now becomes number 14. Bob, is that right?
The old 13 is a dot or a A.
A bullet, yeah, or ABC or something.
Oh,
So-
okay. You're talking about what we changed. It was the printed 11, which we changed to 13, and now we're changing it again.
Correct, so.
So it would be
11,
14.
12.
Yeah, it would be 14. Because that's the introduction to the bullets,
Correct.
okay?
12.
So that's
And how does that
14.
one start?
The exemption in AMC 2155-130A for interior work does not apply where an application for limited site plan review is required.
See, I
Period.
thought 11 is somehow starting with however, so that it.
Oh,
was
we
the-
switched the sentences.
Yeah, yeah.
You are so
some-
right.
So something else starts.
So it
starts
says the exemption, so that paragraph should start, the exemption from limited site plan review applies only to interior projects.
Okay, so I must have written that down.
Correct.
So we got this. Yeah, so that's where I'm gonna get into trouble.
Did we leave that, the
I got
rest?
the exemptions. Okay, so here's what I have. So now tell me what number that's gonna be.
14.
Okay, this is gonna be
14,
number 14.
and it starts out,
Okay, I'm gonna read it, and then you tell me if I got it right.
all right,
The exemption for interior work in the fourth sentence of 2155-130 does not serve as a prohibition for planning and zoning to consider interior solutions where planning and zoning is reviewing renovation project compliance with AMC 2150-320 and 2155-130.
I don't have that, I must tell you.
Okay, so maybe I don't have that one right.
Yeah, I have what Vern had or something.
Okay,
Yeah. Okay,
so let's.
that starts out, the exemption from limited site plan review applies only to interior projects, comma, if the
Okay, you're
effect,
talking faster than I can write.
I'm
so
sorry,
The exemption from limited
site plan review
site plan review
applies only to interior projects, comma, if the effects are limited to the interior.
Okay. I thought we deleted that section, that last piece.
That's what I was just asking.
We-
If the effects are limited,
There was a period right after projects,
okay,
and we also, in the exemption, we added in there contained in the fourth sentence of AMC 2155-130.
Right, so that's how I had it. So I had the first part, the exemption for, okay, so I had it wrong because I had the exemption for interior work, but it's, so what does
remember
Bob
we
have?
switched the
Right,
sentences
I
around.
know. So Bob, what do you have? Start from the top and we'll try that.
The exemption
Contained
contained
in the
in-
fourth sentence of AMC 2155-130
excuse me,
from limited site plan review applies only to interior projects,
projects,
period.
Period.
Okay, so.
And then it goes, however, the exemption,
Okay, so let me get the first part right, because I picked up on the however, so let me get this
Okay.
first part right, because it's wrong in my notes. So,
And I think we do need, if I may, to say interior only projects. I think that modifier is important. Because
think
that, if we just say interior projects, well, I got a project that's both, so how do I deal with that? I mean, interior only. I think
or standalone interior.
standalone interior projects.
Something like that.
all right, so
Yeah.
let's start from the top, enjoy it.
Okay.
The exemption
Exemption. Contained
contained
in the fourth sentence
in the fourth sentence
of
of
C 2155-130A
Mhm.
applies to interior projects only. No,
It's interior
To-
only project?
Interior.
to
only.
interior only projects.
Yeah.
The other way around.
Okay, so is
That sounds better with that in there, limits it.
Is that a period then?
Yes,
Okay,
period.
Then,
the next sentence.
okay, so wait a minute, so this is number 14.
However,
Oh, wait a second, wait.
this
I
is
have-
part of 14.
I know, but I have to find my note for that, because otherwise it doesn't, I won't be able to find it. Okay, so then, however, and then I pick up with the beginning of old 11?
Yes.
Yes, however,
Okay.
the exemption. For interior work.
Well, I think we
And the
changed
exemption in
that.
2155-138 for interior
Yeah, we
work
added that in.
Yeah, that's right, we added that.
Does
Okay.
not apply,
Where an
I thought you
application,
took out, wait a minute, when, I have several things marked out there. Anyway, does not apply to, when?
When,
no, we said, where an application for limited site plan review is required.
Agreed.
Okay, so we kept in where?
Yes,
Okay,
we,
so,
you can change where to when, that I don't think
okay,
that
well, I
makes,
think,
if you like that better.
I'll just leave this where right now, so. However, the exemption for interior work does not apply where an application for limited site plan review is required,
Here,
period.
okay.
And then what happens to, if anything,
And then we have number 18. At least that's what my note shows.
yes,
Okay.
18 comes right there.
Simply add the sentence, no number. The exception for interior, just as
Yeah.
it pretty much reads right now.
Okay, it's quite a puzzle.
It is a puzzle, and I'm really worried that you may not be able to figure it out tomorrow. That's my real concern, Julia.
I know, lots of times I try to do it right when we're done, but I don't know if I have it in me
It's a long
to
day.
do
It's
this
been a long day.
tonight.
And remember, we had a bunch of bullets that followed what is originally labeled as number 15. You see that? The Planning and Zoning Commission is not limited by the 10%
Right,
cost.
so I have the ABCD here, so.
That follows,
Just have to-
yes, that-
Okay, so that follows here. Let's see, so bullets go here.
Yeah, but 15 is not a bullet all by itself. The bullets come afterwards.
Right, 15 is the overarching sentence.
That's the
Oh,
over,
so I
that's
get to
the
say, I keep-
introductory sentence.
Okay, so 15 goes here.
Yeah, the introductory sentence.
Okay, and is 15, old 15 and new 15?
Yes.
Yes, something like
How about
Yes.
that?
that. Oh, wow, it fits.
Symmetry and.
Yeah, yeah.
It's a sign.
And that 15 says, the Planning and Zoning Commission is not limited by the 10% cost limitation in its review of the renovation/remodel application of the limited site plan.
Are they proposed?
We added proposed in there, yeah.
the
Site plan
proposed-
amendment.
Correct.
Site plan amendment.
Okay? Period.
Julia's
And-
gonna make them all parallel.
Yes, she will. Her computer does that automatically.
Fancy.
And then we have the bullets.
Right.
And the first bullet is the second sentence of paragraph 15.
Right.
And then we have 16
Let's see, B
and
was
13. We have how many bullets? We're at 4?
We got
A, B, C,
One,
D.
yeah.
2,
We
3,
had-
4.
Yeah,
Okay, good.
okay, so that was real 15. So then,
We have 16.
and is 16, what is new 16?
Existing. Oh, no,
No,
that's a
it's
bullet.
not.
Okay. The new 16 is what was printed there is 17.
Okay.
The intention of the last sentence. Correct. And the 5 enumerated considerations is to provide a flexible framework for Planning and Zoning Commission review, but the flexible framework does not allow the grandfathered LRE to move further from compliance than it was, then or as, then. We'll
And I
change
put
it.
then
And-
it was,
Then it was May 8, 2001.
okay, then it was.
Put that
not.
paren behind it.
Yes,
And then in parentheses, this is what has been referred to in the record as no backsliding, in quotes.
yes.
You there?
I think we're there. And then we have number 19.
So that was 17.
Which is now 17.
And so then what's new 18?
Okay, would be, yeah, that's on the next page.
Which was old 19?
Yes,
Okay, and that's because old 18 is
18
not.
moved up.
moved
No
up
number.
to number 14.
Correct. So, number 9, the old 19 is 17 then, right?
Yes,
Okay.
that's number 17.
No, old 19 is 18. You just said that 17 was the intent of this last sentence.
No, that
And
last
we're in the
sentence moves up.
factors.
The
Did I mess
intent,
up?
did we get the numbering wrong, Wayne?
I don't think so. I'm tracking with you.
But
What I
yeah,
have is number 7, the old 17 is now 16. You had,
I think so,
the old 17 is now 16,
yeah.
yeah, the old 15 is 15 again, right?
right?
The old 16 is an A, B, C, or D.
Right,
And
okay,
then 17 is now 16,
Okay,
and
so
so
that
Yes.
that's 15.
okay,
Okay, so, and turn to the next page.
right.
Okay.
And that is
Number becomes number 17,
17, okay.
and it starts out the pending litigation between the applicant and others in federal court, comma, the assertion that site plan amendments violate CCRs, and you were going to spell out CCRs, do not or does not empower the Planning and Zoning Commission or the Board of Adjustment to opine on the merits or to render any decision regarding it, period.
Regarding the litigation.
That's fine. Period. A dispute over CCRs is non-jurisdictional to the Planning and Zoning Commission and shall not be considered. Same paragraph, just follows the sentence. Okay,
So there is no 18, it's just a follow-on sentence.
correct, correct.
So then, that's the end?
That's the end.
But we can stay
The
later. if we wish.
excruciating end. So,
So, I
now,
mean, so you go from there to pass and approve?
yes, because if you look at the previous one that we had, none of those things applied. And you and I went through this with a fine-tooth comb. So it's not a final decision, so we don't have to worry about it. We don't have to say in all other respects the resolution is approved. We don't substitute our independent judgment. We don't do anything. We don't, so that's it.
Okay, do we have to say that it's not a final decision on the end or anything like that?
I don't
might
think
have to
so.
look at that.
Take a look at it if you get a chance, but I don't think you need to. Because it only talks, if my memory serves me
Well, remember
correctly.
they had that change in there and then, that somehow, there's some quirky thing, but anyway, that would be the only, that's why I took out all those other ones, because I
Yeah.
didn't think that.
No, they don't apply.
So they don't apply, but I left that rule for number 3 about, even not the final.
Yeah, make a
Mine-
question mark.
Yeah, yeah. So I got a
Okay.
question like that.
All right, now here's what I want you to do. I want you to go home and tomorrow morning, you take a look at it, and if you have any questions at all,
Get a big, tall, quad cup of
I woke up
coffee.
in law school,
I
first year
am-
law school, and I just sat absolutely right there and go, man endangering state of mind, you know, and I was like, just,
well, what I'm trying to tell you is that my office is right around the corner, and I'd be happy to come over with my notes so that we can go through things, because we do need to meet tomorrow happily at 4 o'clock.
right, and I'm certain, unlike today, which I'm sorry, Barrett dutifully called me at 3 o'clock, and I said, Lisa, do you have anything, to send me? And I go, no, I'm going to be using every single second right up until the time. So he said, okay, I'll let you go, bye. And so, but I know that tomorrow I will be able to send you
That-
a,
Well,
and so that
I'll
we
be
can-
pleased to see it
so that
when
we,
I get it, but
so
don't
that-
worry about it.
Yeah, but I mean,
Okay,
it's going to
so-
be helpful to me if we might, that's this puzzle, we might have a conversation, but it'd be great then if you got it.
And I'll be happy to come over.
Okay.
Okay? All right. Anything else for the good of the order? We will then adjourn until
there was-
2 p.m. Yes, ma'am.
Excuse me, I wanted to say something, may I address the board?
Yes, go ahead. I know what you want to say.
As I was typing on this late this afternoon, immediately before, pretty much before the meeting, my computer flashes when I get an email. And it looked to me, and I didn't either have the inclination or the time to follow it through, but it looked to me that there was noise out in the atmosphere and I don't know if there was something that could have been sent to board members, could have been sent to anybody else besides me from one or, but potentially from one or more parties to the case. And so should you find that something like that got sent to you either by email or otherwise, or ended up in your junk box or anything, my request is that you just ignore it and don't open it and don't read it. It's ex parte communication as far as I'm concerned, and I can't tell you more about it because I didn't, like I said,
Okay.
have the time. I didn't want to be influenced by in what you were doing here myself. So
I assume neither one of you received that. I did not.
Nothing was in my inbox,
Okay.
but I had a large number that were in the spam box that I haven't gone through and looked at.
All right.
Usually I just
This
assume.
is just an admonition that ex parte contact with this board or its members is strictly prohibited by code and will simply cause significant problems in the decision-making process of this board. So, to the extent this can be relayed, and Barbara, maybe, I don't know if you saw anything of this sort. If that comes, if you see it, if you would please repeat that admonition that ex parte contact with board members is not permitted by code.
I would be happy to do that.
Okay? And thank you for bringing that to our attention. All right. Anything else that anybody wishes to address at this point? Mr. Stewart?
Should we go through our computers and verify at the next meeting that we did
No.
not?
no.
No,
Just, okay.
just forget it.
No, I have nothing.
Okay.
Yeah, it's in your spam box.
Mr. Adams?
There.
Nothing further?
Delete.
Julia, anything further? Barbara, anything
Nothing
further?
further.
All right, we're then stand adjourned until tomorrow, 4 o'clock.
In this room.
Yes. Thank you.